Live stream audio check, 1, 2.
Well, good morning, ladies and gentlemen. It's 9:30. The inquiry is resumed. Can I just remind you all, if you've got a mobile phone, please make sure it's switched off or on silent whilst the inquiry is sitting, and hopefully there's a fresh attendance list circulating today. Good, thank you. Just a couple of things from myself before we start. I heard from the Inspectorate's case officer on Friday, I think it was, that someone following the inquiry on the live stream wanted to know if they could see details of the latest landscaping scheme, the February 22 one, and where they would find it. Knowing that it was part of Mr. Clarkson's rebuttal, I checked on the Council's website and realised that the rebuttals hadn't been uploaded, nor had any of the documents that were handed in at the inquiry. So can that be either, has it been addressed, or if not, can it be, please?
Yes.
Yeah. Good, thank you. My second point, hopefully later today we'll be looking at both conditions and the Section 106 agreement. I'm sure that on the Section 106 it has moved on from the latest version that I saw, but just to point out, on the latest version that I saw, it did appear to me that the planning application number was incorrect in the page 7. So again, if that hasn't been picked up, I'm sure someone will now address that. Thank you. So, is there anything from either party before we continue?
Just one thing from me, sir, apart from so the reason I'm sitting here, as you might have guessed,
yes,
it works better with the witness.
Yeah, I realise, thank you.
There's one document which I indicated, I think, yesterday on Friday, I can't remember now, to Mr. Leader we'd be submitting today, which is a recent appeal decision, coincidentally also involving Persimmon, but that's by the by, in a case in East Cambridgeshire, decision of Inspector Boniface, and it deals with the approach to most important policies, and there's an aspect of that decision which Mrs. Ventham is going to explain her view that it's relevant shortly. So I'll just hand that up.
Thank you. Yeah. So, bear with me. This is right, thank you. Anything else? Anything from you, Mr. Leader?
Yes, thank you very much. What I've got is a note from Miss Richards which picks up on some of the issues we said would address you further in respect of the 5-year supply discussion. So I'll hand you a short note from her. And there's also a copy of the adoption plan of, well, amongst other things, Grange Farm Road. It's the whole of the North End Road estate at Yatton, dates from May 2000 adoption plan. And so what I invite you to note is that when you look at the cul-de-sac, which is the part of Grange Farm Road which abuts the appeal site, you will see that it's not easy to read the annotation possible future access indicated where the cul-de-sac abuts the edge of the appeal site. So I could just hand that in, so it'll be subject to submissions in due course.
Okay, on that point though, Mr. Leader, I realised when you handed in last week the land registry, the office copy entry, there was no plan with that. Now I know which title we're talking about because it was in Mr. Thorne's, yes, but I didn't know whether there was a plan that should have been accompanying that.
So yes, I'll stand over this so while we talk, because otherwise apparently I'm not audible.
Yeah.
Live streaming. So yes, ST2 is in fact the title plan, but what's happened is the land registry notation has been sliced off the top. So what I'll do, sir, is ask Mr. Thorne to provide us with the plan that goes with the office copy entry, and then you'll have the two to put side by side.
Yeah, I've got that. Thank you. Right, so that's the adoption one. Yeah, thank you. Yeah.
Could we have this electronically as well? Yes. Preferably this morning, if we could. Thank you. If you could bring it.
Right. Is that everything from each side? Yeah. Okay. Yep. Okay, so when you're ready then, Mr. Banner, if you'd like to introduce your witness, please.
Thank you. So it's Ms. Catherine Ventham, and from Ms. Ventham you should have a proof, a summary, and the appendices.
Yep.
As with the other witnesses, if I may, I'll take the summary as read, introduce the witness, and then ask a few questions. And by way of introduction, you set out your qualifications experience on page 1 of the main proof, where you tell us you're Catherine Ventham, you have a BSc degree with honours in human geography from Reading University and a master's in city and regional planning from the University of Wales, Cardiff 2000. You're a chartered member of the RTPI, a planning partner at the Birmingham office of Barton Wilmore. You became a partner in 2013, and you set out what you do at Barton Wilmore and your previous experience on the rest of the page. Is all that information correct and up to date?
Yes, it is.
Excellent. Thank you. In which case, let's start, if we may, with your view on what are the sort of key issues, key dividing lines, issues of dispute between the parties.
Thank you. I think when we heard Mr. Muston's evidence, insofar as any dispute between or difference between myself and him, I think Mr. Leader distilled it down to 4 points, which were character and appearance, albeit I don't actually deal with those points. Mr. Smith takes those points. The approach to SA1, the approach to policy CS13, and the weight to benefits. But I think the starting point really is that it is agreed and confirmed by evidence in chief and cross-examination that in respect of this appeal and any alleged harm, that relates solely to the provision of the access road through the remnant orchard, and that no objection is taken in respect of the residential element or the pond and the play area. So effectively what we're dealing with is the alleged harm caused by a section of unlit tarmac. And what I would say in that then is that if you then further distill that down, insofar as it relates to planning matters, the key difference between myself and Mr. Muston is the 4th bullet of Schedule 1 of SAP 2. And what I would say, because I don't think it's come out very much so far in this, is just a reminder, sir, that this application did have a strong officer recommendation for approval twice. And if I turn to paragraph 1.7 of my evidence, and I just set out there that in relation to some of the matters that we are going on to discuss, the officers concluded that the options for an alternative access to the allocated site avoiding the orchard has been thoroughly investigated, and there are none that are reasonable and deliverable. And then in the following paragraph, I highlight that the officer's conclusion was that the access road itself, obviously that's just a reminder that that is what we're talking about at this appeal, that would not have an unacceptable impact provided that Natural England's requirements can be met. And then if I turn to paragraphs 218 and 219 of my evidence, I think it's clear from the extracts of the committee report that I have included there that the investigations into the alternative access were joint. It involved the council and the council officers as well. So in the first paragraph that I've cited, it says officers have made extensive investigations into the potential for an alternative access. So this wasn't just the appellant, this was a joint approach to looking at this. And then turning to the following page, page 10 of my evidence and page 11 of my evidence, again at the bottom of page 10, it says that with regard to the alternative access, this has been investigated. There are no deliverable, reasonable alternatives. And then finally, so just looking at the extracts that I've included at page 11, on page 11 of my evidence, where it talks about the benefits attributed to the New Orchard tree planting, the benefits of approving housing in the village in accordance with the adopted plan, and then again the final officer conclusion, which I include at my paragraph 219, where it says that the options for alternative access to the allocated site through the orchard have been thoroughly investigated. There are none that are reasonable and deliverable. And then officers go on to conclude that in the event that the tilted balance were applied as it was at that point, that the harm of approving the development does not outweigh the benefits.
And in terms of section 38.6 then, is this a case in your judgment which is one of accordance with the development plan, either complete accordance or accordance as a whole, or is it section 38.6, tilted balance? How do you see the section 38.6 analysis?
Thank you. So my starting point is one that of compliance with the development plan. When we turn to policy SA1 of the plan, which I do so in a number of sections in my evidence, but just turning to probably taking it to paragraph 4.43 of my evidence, where I list out the bullets, they're not bullets, but the way that it's dealt with in Schedule 1. And I think it is agreed that as I said, the only dispute between us is the provision of the fourth bullet, which says that the provision of the access road across the orchard will only be considered if alternative access arrangements cannot be made and subject to a suitable scheme being agreed with Natural England. And it's my view that we do meet that bullet. And then with regard to the other policies in the plan, they are primarily related to landscape and ecological matters, and are dealt with by Mr. Smith and Mr. Clarkson in their evidence, to which I refer, and their conclusion, as the professionals qualified in those respective areas, is that there is accordance with the development plan. So drawing all the evidence together, my view is that the starting point is that the scheme is in accordance with the development plan, and obviously it is as we talked about, it is an allocated housing site. Moving on from that, if some significant breach were, or some significant conflict were identified, and I do sort of draw attention to the comment that Mr. Muston made in cross-examination, which was that we could potentially be found to be in breach of bullet 4, but still be found to be in accordance with the development plan. And my view is that if there were any significant conflict identified, that there are other material considerations which would be brought into play, namely the package of benefits which goes to supporting the scheme, and also that, in my view, when you read the MPPF and the development plan as a whole, if there is any conflict identified, that conflict is relatively limited.
And then let's just say you're wrong about it. So let's say the inspector doesn't agree that there's either complete compliance with the plan or accordance with the plan as a whole,
Yep.
on the pulling in different directions point. So we're in section 38.6 territory. How do you see the framework being of assistance in that context?
The framework, then I would look to paragraph 11D of the framework and the application of the tilted balance, and in my view there are two routes to the tilted balance. The first, excuse me. The first is that the policies are deemed out of date because of the shortfall in 5-year housing land supply, and obviously I do appreciate the council takes a different view in that regard, and I would obviously highlight that in the event that a shortfall is found, and I believe there is a shortfall that the council did previously consider, that the benefits outweigh the harm. But also, and I would say that's a sort of a relatively black and white entry into the tilted balance. A second entry into the tilted balance by way of more of a planning judgment is that the most important policies are out of date because events have moved on. And in Mr. Muston's, I can't remember his evidence in chief or cross-examination, apologies, but he did agree that that was, that the fact that events have moved on was a second point of entry into the tilted balance. And so, therefore, from my perspective, there are two routes in this case into the tilted balance, and therefore in the event that there was decreed to be some breach of the development plan, and that breach was significant, that would have to be looked at in the context of the tilted balance and the harm needing to significantly and demonstrably outweigh the benefit. So, in essence, there are multiple routes to the grant of planning permission. There's compliance with the development plan, which is my starting point. There is the route of other material considerations and the route via the tilted balance.
Thank you. Well, let's just explore some of those routes in a little bit more detail, but starting with the compliance.
Mr. Banner, I wonder if you could just move the microphone a little bit
so
closer
sorry,
to
yes,
you. I'm not quite sure.
It's I think I might have to move myself closer to the microphone. It's easier. So just starting with accordance with the development plan, first of all, and exploring that in a bit more detail. How do you see on the three main issues set out in the reasons for refusal, how do you reach the position that there is in fact no conflict at all?
So just turning to the reason for refusal, and the reason for refusal, obviously the starting point is the proposed road. So it's very clear we are just talking about the road. And then the conclusion is that it's an unacceptable loss of trees, hedgerow and habitat. And those are the sort of that's the starting point. And in coming to that starting point, I would sort of just like to confirm that the policy SA1 does allow for an access road to come through the orchard. So in order for an access road to come through the orchard and connect up to the main road, it is going to connect somewhere along Moor Road effectively. So no matter where you come out on Moor Road, there will the impact in terms of, or the alleged impact in terms of rural character and loss of hedgerows, frontage to Moor Road, that surely has to be accepted the moment you decide that there is a route through to putting an access onto Moor Road. But just dealing with the three items that are set out in the reason for refusal, firstly just turning to the trees. At the time I wrote my evidence, there were once you get into the site, so there are 6 trees, of which 4 were standing. As of yesterday, as of Friday, I believe there are now 3 trees standing. We do need to clarify that, but it does look to me, sir, and there were some of us on site yesterday, we couldn't actually get into the site because there are horses and the gate is locked. But it does appear, sir, that in group G6, which is the group of trees that would be near to the pond, so along the closest to the north-eastern boundary, it does appear that the tree that was standing there has now fallen.
And is that one of the two questions to follow up? Firstly, is that one of the trees that was going to be relocated from its current position?
No.
So what does the fact that the tree has apparently blown over in the storms over the last few days, what does that tell the inspector about the reliability of the arboriculturist's judgment in the arboriculture report that the standing trees haven't got very long to stand?
Yes, so you will have seen that when we put the rebuttal evidence in, that we put a note in from Mr. Pearce, who concluded, who's the appellant's arboriculturalist, who concluded that the remaining trees on site, which are all category C trees and in a condition of terminal decline, he concluded that they were unlikely to last beyond a 10-year period, and obviously one of them has potentially now fallen already. So we're now in a position where I think we have 6 trees on site, of which 3 are standing and 3 are fallen.
And is the position in relation to these veteran trees, if the appeal proceeds, is it your judgment that we're in a situation of no harm or some harm or betterment? Which of the 3 is it and why?
Sure. So my position is one of betterment in terms of the veteran trees. The veteran trees are defined as veteran not because of their arboricultural importance, but because of their ecological importance. I get into ecology now, but I'll try not to go, because obviously we haven't done the ecological session. So the trees are veteran, because they're defined as veteran because they contain dead heartwood, which is the ecological significance. It relates to their role in supporting the orchard tooth fungus. And our view is that in terms of the trees which are currently on site, obviously group G6 which has 1 fallen and 1 standing tree, that remains as it is. So the trees that are affected by the proposal is group G7, which has got 1 standing tree and 1 fallen tree. We are proposing that group G7 be, or that the 1 standing tree at G7 be translocated to adjoin group G1. Group G1 is where the orchard tooth fungus can be found, albeit I believe it hasn't been found in the last couple of years, but that's not unusual. And in order to serve is maybe not the right word, but in order to be of use to the orchard tooth fungus, the tree needs to be standing, because if the tree falls, then the dead heartwood that supports the orchard tooth fungus becomes moist effectively, and actually the orchard tooth fungus requires dry dead heartwood. So as it currently stands, there is the potential that the remaining tree in group G7 will fall, and therefore it will fall, it will become more, the heartwood will become moist, and it will serve no benefit. Through the translocation of G7, then the tree will be supported, it will remain standing, and therefore it will continue to provide the dead heartwood habitat. I'm sure obviously the two ecologists will explain this probably far more eloquently than I will, but whether the tree is alive or dead is not the issue here in terms of the ecological importance. That the key is obviously the standing of the tree. So from my perspective, the relocation of the tree, of the 1 remaining tree at G7 will actually deliver a betterment in terms of ecological matters and the veteran trees.
I'm most terribly sorry to interrupt, but apparently we've got a problem with the microphones on my learned friend's side of the room, which is interfering with the live stream, or rather, putting it bluntly, we aren't really live streaming what my learned friend's witness is saying. So
right.
I've been asked whether we might just pause for a few minutes while we sort it out. I'm so sorry to interrupt.
I think we need to, if that isn't being broadcast correctly.
Yes.
What's the best thing to do for me?
So if we could have just 10 minutes to get it sorted out.
Okay, well, it's 5 to 10. Let's adjourn. I'll adjourn now until 10:05.
Thank you very
and
much.
See how things have gone.
We have solved it, we think.
Oh, simple as that.
Well, I'm not sure. Shall we make sure that we are
Sounds like the classic toad off the toad on again.
Yeah, let's do as I've said. Let's just take that 10 minutes and see how things are. Okay, so I'll adjourn. We'll resume at 10:05.
Thank you very much. Just take the time.
Yeah, see, I'll leave it in your capable hands. I'll get it.
Sorry about this.
He learns something every day, don't you?
We've got an interaction between a couple of microphones. We're just trying to work out which ones exactly.
Exactly the same thing. It's quite fun. I have. It is.
It's amazing what you learn because it's just, but it's just that fact, isn't it?
Yeah.
Because, and it's just it's the fact of the way it's applied, isn't it? That actually, it's just really.
But the thing, very stuff like things I did was the bond of it campaign actually first of all six times, and the issue of whether it's this meadow, this one of development service, was ancient woodland. It had no trees on it.
Yeah.
And I remember saying, well, what's the purpose? Because the trees come and go in ancient woodland, and then the soils.
Yes.
And then the Secretary of State ended up finding this meadow was ancient woodland.
Yeah. Because
That single tree, because it
Because it
goes
goes-
back to what's it being protected for.
yeah, exactly.
Trees didn't kill it.
Yeah.
If you're actually keeping or making it better than they're protected for, then it doesn't matter.
Yeah.
Fascinating. Take advantage of the break.
You mocked me. I was going to say, do you know when you came in, you said I'm travelling light. I was like, that's impressively light.
Gentlemen. Ms Venter, I'm not quite sure how much was missed there and whether or not you need to do a bit of rewinding. I can perhaps be advised on this.
I think it was the quality rather than it not streaming at all, so I suggest
We can carry on.
Okay.
If you're happy with that, sir, that'll probably come as a relief. So we did, within the context of accordance with the plan and the three main issues raised by the reasons for reviews, we've done trees.
Yep. I
I think next point was hedgerows. What's your analysis about accordance? And perhaps you can also explain, do you see kind of the precise calculations that gains as really relevant to this, or how do you approach your view as to whether there's compliance with the development plan in relation to hedgerows?
Yeah, so in relation to hedgerows, the sort of the mathematical element of it is that there's 40 metres of hedgerow lost to form the site access, and then 10 metres of the central hedgerow. So 50 metres of hedgerow in total. What I would flag is that is it's hedgerow which is currently in poor condition, and that actually we've got 260 metres of new species-rich hedgerow planting going in. We will also have a landscape and ecological management plan, which will also improve the overall management of all the hedgerows on site. So again, there'll be a qualitative improvement of the hedgerow along the frontage as well.
Thank you. Then third point, so the habitat, your analysis there.
Yeah, so in relation to the habitat, as obviously I've already sort of covered the tree element, but the grassland within the orchard, it will again be covered by the landscape and ecological management plan, and it will be managed to create a species-rich grassland, and that in itself will also deliver enhancement opportunities for bat foraging. Plus, there'll be greater opportunities for the orchard to fungus to be maintained and to infect other trees. And I should flag it's not a harmful fungus. But the sort of do nothing scenario in this instance is that the trees fall over and the opportunities for the orchard tooth fungus are reduced because there is no orchard planting. Yes.
And in terms of accordance to the plan, in respect of impact on landscape and visual character, what planning judgments do you draw based upon Mr Smith's evidence?
Based upon Mr Smith's evidence, he concludes that the impact is localised, and he also covered in his evidence the fact that when factoring in the road across the site, that could form part of the potentially form part of the baseline position for the assessment because it is allowed for under SA1, and he considered the impact to be neutral. So therefore, taking on board his conclusions, I would suggest that any harm in that respect is limited.
Thank you. So if we can turn then to policy SA1, we had a discussion last week with Mr Muston about the distinction between bold text and the yellow box in Schedule 1. How do you approach this issue, and how do you approach the relevance or otherwise of that debate?
I mean, there is the policy SA1, and the way that the SAP plan is set out is there is a.
Can I just pause you and I'll get the.
Should we get it out? Yes.
So it's one of the D ones, isn't it?
Yes, it is.
Yeah.
I think it's D3. Thank you.
Yeah.
Thank you very much.
Policy SA1 is at page 14, and then the schedule is at page 52.
Okay. Okay, thank you.
But do continue.
Yes, so I think what what we can see is that there is a very clear way that the plan is set up, which is the policies, which are headed policy, are set out in yellow text boxes and have a policy heading above them. If I then turn to the schedule, that is set out differently. There is no box around that. There is, in my view, it is set out and treated differently to the policy text. I would suggest that the reference to the allocations which are in there do inform the bold text policy, but I don't see them as forming part of the policy. But in reality, what difference does it make, which I think was the second part of your question? Very little, to be honest. Mr Muston agreed that that we could potentially breach one of the criteria, and as I said, one of the bullets, and the only difference between us is bullet 4. But we could breach that and still be deemed to be in accordance with the development plan as a whole. So in reality, in terms of the difference it makes little difference in terms of the assessment of this case.
And in terms of whether there is or isn't a breach in the first place, how do you, in the context of this case, how do you read the critical words of the fourth bullet, or fourth provision?
Well, as a starting point, these are items which need to be taken into account. So they're not mandatory. They're things we need to have considered. And then what it says is that the provision of the access will only be considered if alternative access arrangements cannot be made and subject to the suitable scheme being agreed with Natural England. Therefore, even if we can demonstrate that actually there are no alternative access arrangements and that we have agreed a scheme, or we can agree a scheme with Natural England, then there is permission within this bullet for us to take an access through the orchard.
And then the drilling down on the three aspects, then the provision of the access road will only be considered. Firstly, pausing there, any significance in those first words?
Well, as I already said, I think that the starting point is that the principle of the provision of an access road through the orchard can be found to be acceptable. So it wouldn't be logical for the council to be advancing an objection in principle. It can only be the detail of the scheme rather than objection to the principle. I would also flag that in considering we dealt with the previous application in brief. I think it was Mr Muston's evidence in chief, when the council did refuse the application, a previous application, which was wider than just the road. The concerns there were wider than just the road, but they didn't refuse it under policy SAP 1.
And then access arrangements cannot be made. Reading the plan, reading that provision in the context of this plan, what timeline or time frame do you consider the provision cannot be made to fall? Is it looking cannot be made ever in history, or some other time frame?
No, I would say within the time frame of this plan, and this plan, as we've already talked about, runs to 2026.
And what's the undisputed evidence about whether alternative access arrangements can be made within the lifetime of the plan?
Well, what we've sort of been through already within this is that the alternative access arrangement cannot be made within the time frame of this plan. It's been agreed. Well, it's shown within the council's 5-year housing land supply evidence, which obviously goes beyond 2026. The site has been removed from that, and Mr Muston has also confirmed that the timescales for the delivery of an access through adjoining sites would mean that it would probably be taken outside of this plan period.
Anything else you want to say on that, Lim? Or?
I think just sort of one final point really, which was that in terms of the phrase cannot be made, the case that's being advanced by the council is that we could come through the rugby club land, just as one of the two examples. Cannot be made can't surely require, therefore, provision of an access road through an unallocated site on a development which would come forward outside of the development plan. That can't be, as a matter of logic, you can't have an allocated site reliant on the delivery of an unplanned, unallocated development. And I would also say that when we were then looking at this policy with Mr. Muston, and I think the conclusion was that what else cannot be made mean other than matters of land ownership. And with regard to the Grange Farm access, it is set out in 4 proofs of evidence plus a statement of common ground that there is third-party land owned by now Taylor Wimpey between the end of the adopted highway and the boundary of the site. And it's acknowledged that could potentially form a ransom position. So there is land which is not within the control of the appellants, and my understanding is, and this was prior to my involvement with the scheme, but back in 2018, the council confirmed at that point that they would not use their CPO powers to acquire that land. With regard to the rugby club site, that is currently functioning as a rugby club, as set out in the officer's report to Planning Committee. The redevelopment of that site, as it currently stands, needs the input of Sport England. It also requires the existing, or the pitches to be relocated and up and running before the redevelopment of the existing site can happen. And we're looking at a period of somewhere between 2 to 3 years. And as I said, as far as I'm aware, as of now, there is no planning application which is in for that. The council have suggested, it's in the draft Regulation 18 plan, that there will be, or that they're looking at a combined policy for the 2 sites. We don't have any detail of that policy, and as the council themselves accept, that only at this stage we're at Regulation 18, or pending Regulation 18, therefore that plan can only attract limited weight. So at the moment, I would suggest that that there is no basis to secure an application through the rugby club land.
Thank you. Then, the final bit, suitable scheme being agreed with Natural England. Any more observations you want to make in relation to that limb of the 4th bullet?
Natural England, at this stage, have set out that they have no objection to the proposals. They have made recommendations, and they are recommendations that the appellant has agreed to. Obviously, we've talked about the fact that we've put a slightly revised landscape plan in, but that plan is, I think, in all parties agreement, materially better. And the proposal has additional planting and removal of a footway, which could have given could have had a more negative impact on the Zoe Rin. So if you look at then the basis of Natural England's requirements and what they set out, I have no reason to think that anything that we've done would offend Natural England.
Then, let's say, for the sake of argument, it's concluded that there is some technical breach, the 4th bullet, or breach, say, for example, access arrangements, it's considered could be made, but there's no material or significant harm doing it the way we're doing it. In terms of looking at compliance with the plan as a whole, first of all, how would your analysis flow from that situation?
Sure. I mean, I think if I look at the overriding objective of that bullet, the overriding objective of that bullet is obviously one of not causing harm, and therefore actually if there is an alternative access, but it is agreed that the appellant's scheme doesn't cause harm, and actually, as I said, it's our view that we can bring about a betterment, then in reality the fact that there is an alternative access available is a technical breach, but actually one which is capable of being outweighed by other material considerations, and a position being taken of compliance with the development plan as a whole. which I think was a point that Mr Muston agreed with in evidence.
We might come back to that when we look at the Soham case. But
Okay.
anything more you want to say on development plan before we get to the tilted balance?
No, I mean, I think just in terms of the application of the tilted balance, again, just to come back to the council's case as expressed through Mr Muston, was that if it was found that the council couldn't demonstrate a 5-year housing land supply, then policy SA1 and the accompanying schedule were considered out of date. Yeah, I think that's probably as far as I need to go on that.
Great. So tilted balance then. If there isn't a 5-year supply, that's flows automatically. Probably I
Yes,
don't need to say very much
correct.
more about that, if anything.
Yep.
On the question of whether, even if there is a 5-year supply, the most important policies are out of date for the purpose of paragraph 11, there's nothing in the written evidence of the council. The only point made orally by Mr Muston is he disagreed in relation to CS13 being within the basket. No other point has been taken about your analysis of what goes in the basket,
Yes.
whether out of date or up to date.
Correct.
So we know that's the sole point of contention. And what's your view about whether, we know CS13 is considered to be out of date, because
Yep.
that's the reason why it said not to go in the basket. So the only issue effectively on most important policies is should CS13 be in the basket,
Yeah.
the most important policies. And just talk us through why you say it should be in the basket.
From my perspective, CS13 is the policy which sets the housing requirement for the plan and the plans that sit alongside it. So the SAP2 plan, it's the policy which sets the housing requirement for those plans to deliver. It's the policy against which settlement boundaries, allocations are all set against delivering that objective. And in terms of the importance of that to the plan, if I turn to page 20 of the core strategy, which I think is DM1, the first priority...
Just bear with me while I get that in front of me then. So page 20.
Yeah, it's page 20 of the core strategy. Page 20 of the core strategy. Priority objectives.
Yeah.
If I look at number 1, of those priority objectives, number 1 is deliver sustainable housing development across North Somerset to meet housing needs through the provision of a minimum of 20,985 new homes by 2026, and that's the housing requirement under policy CS13. So my view is very firmly that the policy CS13 is a most important policy, and one which, it is the council's case, they do agree, or they did agree, in Mr Muston's evidence, although it was out of date.
Sorry.
No,
Please, after you.
And so what I was going to do, in just noting that point has been taken by the council, we handed in this morning an appeal decision which Mr Banner has already referred to, which was from last month, January this year.
Yeah.
Sorry.
If we get that up, should we start on page 2 and just kind of coordinate through the policy? This is an East Cambridgeshire decision. Paragraph 9 tells us that the relevant policies the inspector was looking at. Growth 1 is the requirement figure. Do correct me if I've got it. Then growth 2 was the locational strategy, which had a sort of fairly familiar don't develop outside the settlement boundaries unless you fall into certain categories type policy.
Yeah.
Except for allocations. Growth 4 was the allocations policy,
Correct.
reliant on the figure. 13, growth 1 is out of date because the plan is now more than 5 years old and the housing requirement can't be relied upon, so that was a standard method.
Correct.
Authority. And then overall, I think probably paragraph 20,
I'm sorry, I didn't hear that.
paragraph 20
Oh,
on
yeah,
page
sorry.
4,
Yeah,
a
paragraph
number
20.
of general policies.
Yeah, so From my perspective, so this is it's a beautifully clear decision, and actually a very methodological approach to this point. And I think you can apply this approach to the policies in this core strategy. And what this inspector concludes at paragraph 20 is that policies growth 1, which is the housing, which is the housing target figure, so that our equivalent policy is CS13. Then they also conclude that growth 2, which is effectively our equivalent of CS14, and growth 4, which is the policy which allocates the sites, they are most important for determining an application for residential development, because he concludes that together they set out the amount and locational strategy for the delivery of housing, including restricting development outside settlement envelopes. And so for that reason, he concludes that they're all out of date for the reasons that he has set out, and therefore the presumption in favour of sustainable development applies.
And just going back to paragraph sort of 13, the parties' agreement that growth 1 was out of date, which the inspector endorsed that agreement in the passage you just took us to. Let's just think about this in the context, that analysis in the context of the council's one point in relation to most important policies, which is CS13, because it's out of date and the requirement figure is drawn from the framework, it's no longer one of the most important policies. If that is a good argument, would Soham have been decided in the same way?
No.
And just tell us through why. How would that argument have applied to growth 1 in Soham?
Well, then the same point would have been taken in respect of growth 1, i.e. that it doesn't get to go into the basket in the first place. And
just go right the way then, moving aside from basket most important policies, I said we might come back to this in the context of plan accordance as a whole. If you go right to the end, page 8 of the decision, and paragraph 43, and that was the context for this, as can be seen from the decision. I can lead you on this because the decision is there was a finding of conflict with the locational strategy growth 2 because it was the wrong side of the line on the plan, but no underlining significant harm. So it was a conflict without any real planning consequence. Hence 43, despite a conflict with one important but out-of-date policy, overwhelming compliance with the other relevant policy of the plan, overall in accordance with the plan taken as a whole. Does that lend any, have any relevance to your approach to plan as a whole in the event that the alternative access arrangements can't be made limb of SA4 Schedule 1 hasn't been complied with, but there's no significant harm? Sure.
Yeah, I mean, you can draw an almost identical conclusion, effectively. Were you sure to take the conclusion that we breach the fourth bullet of policy SA1, as we've said, I've already said that policy is out of date. The council have not taken issue with that, and my view would be that there is compliance with the development plan taken as a whole, and therefore the material considerations would direct towards the grant of planning permission. So the same approach effectively as paragraph 43.
Thank you. Anything you want to say, or can we put that away?
No, that's fine.
To one side at least.
Thank you.
And then lastly, in the sort of balance of harm and benefits, if we are in a sort of tilted balance scenario, if we do get to that stage of the mind map, we've sort of dealt with the alleged harms probably, but in terms of benefits that you haven't already raised in your oral evidence, any particular issues you wanted to draw attention to?
Yeah, so the council, the emphasis of the council's case in terms of benefits, it seems to focus around economic benefits, and as a starting point, and again I know we dealt with this in evidence, but in Mr Muston's evidence, apologies, but the starting point obviously in terms of the economic benefits is paragraph 81 of the framework, which basically says significant weight should be placed on the need to support economic growth and productivity. In support of that, with my evidence So I have included an economic benefit statement, which again has gone unchallenged by the council, setting out the benefits that would be delivered by this scheme. And just as an aside, well not an aside, as part of the case really, we mustn't forget the importance of the construction industry to the UK as a whole. I think we only have to look at what has happened in a hopefully post-pandemic era and look at the efforts that were made by, as it was Robert Jenrick at the time, to restart the construction industry in May 2020, so some 8 weeks after we went into the first lockdown. The emphasis that was put onto restarting the construction industry, into allowing people to go out and purchase new homes, allow that to be, allow all of that work to be undertaken despite the very strict lockdown measures that we were under at that time. He also put provisions in place to allow sites to start earlier, finish later, work slightly longer hours at weekends. All of that, to my mind, is all geared towards economic growth and keeping the industry and all the spin-off industries, all the sort of industries that are attracted to whether it be removals, furnishings, plumbers, electricians, etc. All the industries that sort of sit alongside that really. So I don't think we can in any way underestimate the importance of job creation and economic growth for the construction industry.
What about economic benefits? I'm just going through the three limbs of sustainable development. Environmental benefits, we covered those already. But,
yeah, we've covered those already, I think.
And social benefits.
Social benefits. I mean, we're obviously delivering. The aim of the MPPF is to significantly boost the supply of housing, and also we need to deliver affordable housing as well. The council's own affordable housing monitoring document. I include the latest version of that in my appendix. That shows that they're only achieving 87% of their current affordable housing requirement, and obviously it's important to remember that's against the figure which does not currently meet the current housing requirement. And Mr Musson himself agrees. He attaches significant weight to market and affordable housing.
So that part, so that's 87% of effectively a policy on.
Of a policy on, exactly.
Rather than
yes.
the full need.
Yeah.
Very good. Anything more you wanted to add, or is that complete?
No, I mean, I think effectively, I mean, you know, the conclusion that I therefore draw matches the conclusion of the officers twice when assessing the application, which is that in the event we are in tilted balance territory, the harm is not significantly and demonstrably outweighed by the benefits.
Thank you.
Thank
so
you.
That's the evidence in chief. Thank you very much.
Okay, thank you. Just bear with me a moment.
So before my learned friend hands his witness over for cross-examination, there is one matter of updating I need to assist with, which is, and I've just been handed these, there's been a full application made in respect to the rugby club. Now, what I've got is the planning application form and a plan which I've not yet had an opportunity to look at, which is a location plan backed up by looks like a layout plan when I open it up. So, sir, what I would suggest I do, and obviously my learned friend may have a view on this, is first of all hand a copy of this to you and my learned friend. Secondly, let my learned friend look at it. Thirdly, if my learned friend's got any objection to it going in, I probably will have to recall a planning witness or call a planning witness and put it in formally. I suppose, from my perspective, I merely seek to demonstrate by submitting this application to the inquiry that there is a more than fanciful suggestion that a planning permission will be granted, because actually we have a full application made today, though there plainly is a long way to go, not least because, as my learned friends' witnesses observed in their evidence, the rugby club's development would at the present time be contrary to policy. So I recognise all of that, but we've got the documents. May I put them to my learned friend and yourself, so my learned friend's got any objections, can take them, and we'll deal with it from there.
Mr. Banner.
Clearly, if I was you, I'd want to see it. So,
Yeah.
So, absolutely, it's not unusual in the context of a plan, emerging plan for the person behind who's the beneficiary of a potential allocation to put an application in to show a bit of colour without necessarily progressing that. We've all been there. What I suggest in terms of minimising the time in relation to all this, why don't we put it in, park the issue, let's crack on with the cross-examination and everything else, so we're not doing on the hoof or having more adjournments. And then once the cross-examination is finished, we can have a look at it, and if we need to recall the planners in April, to comment on it, we do it, or we do a written note. I'd rather do it that way than have Ms. Fentham and myself, frankly, distracted by this now.
Well, I'm certainly content with that, because we will have the opportunity when we come back, if there are matters that either side's planning witnesses need to be recalled on, we can do that. It may not simply be this matter, it may be other matters. Mr. Leader, are you content with that?
Yes, I'm happy with that. So it's a short point.
Yeah.
We're not here to discuss a rugby club application. We're here to discuss an application by Persimmon on a different site.
Of course.
So put it in, we can take it from there.
Yeah, put it in so we can all see it, and as Mr. Banner says, let's park it for now. But obviously, once this session is completed, it can be perused and revisited as appropriate in due course.
Could I make the usual request for an electronic copy of everything as well, so we can distribute it to our wider team, please? Thank you.
Yes, yeah. Hopefully, I think I hopefully said it when I made my opening announcements, that when documents are handed in, can electronic versions as well. I asked if they be sent to the Inspectorate's case officer, so obviously similarly sent out to the appellant and vice versa.
Yeah, good. So I'll hand this in, then we can crack on.
Yeah, let's do it like that.
So just whilst Mr. Leader has that, can I just ask for a 2-minute comfort break?
Oh, yes.
Just
Well,
2 minutes before we start. Thank you.
Okay, well, we're 10:37, so let's go until 10:45. That's 8 minutes there. Is that okay? So I'll adjourn now and we'll resume at 10:45. Thank you. Well, the inquiry is resumed then, ladies and gentlemen. Mr. Leader,
Thank you very much, sir.
can I just say, when we get approaching 11:30, can you look for a convenient
Yes.
point in your cross-examination? We'll have a slightly longer,
Yes,
more meaningful mid-morning break. Thank you.
of course, sir. Right, good morning, Mrs. Benson. Now, can I just begin in this way? What do you say are the most important policies in this appeal for the purposes of paragraph 11D of the framework?
Yep, I deal with those in my evidence. It is policy, the policy cited in the reason for refusal, along with policy CS13, CS14 and SA1. I'm sorry.
Right, so, just to make sure that we're on the same page, we're going to be concerned with CS4, CS5, DM9, DM10, DM32 as well?
Yes, the policy is cited in the reason for
Well,
refusal.
I only asked because SA1 is obviously cited in the reason for refusal, and you added that in just now. It's at the foot of the refusal, but okay, good. Right, now, which of those do you say are out of date?
And so which of the policies cited in the reason for refusal
Yes,
are out of date?
yes.
If you just bear with me, I'll just...
I just want to be clear on this before we go any further. If it helps you, pages 68 to
That's
71 contain various comments, but as I read your proof carefully, I was left scratching my head to some
Okay.
extent, so I'm just asking you for clarity, then we'll dig in.
So in terms of the policies cited in the reason for refusal, I say that CS4, I say that there are aspects of that policy which, in relation to veteran trees, which don't quite reflect...
No, I've obviously read the
okay.
table, so
Yep.
if you just want to tell me which ones you think are out of date, then we'll go back to them, don't worry.
Oh, in terms of out of date, my view is that all the policies contained within the reason for refusal, plus the additional policies that I've cited, are out of date.
All of them?
The policies cited in the reason for refusal, yes.
Right, okay. And just so I'm clear, when you say they're out of date, is that because each is in some way inconsistent with the framework, or is it because of what you say is the absence of a 5-year supply?
Oh, so, sorry, I think we may be talking across purposes, apologies. So can I just explain the way that I approached it, and then maybe that might clear it up. So the way that I have approached the assessment is to obviously look at the policies and their consistency with the framework, and then effectively take the reasons for the policies which are cited, in the reasons for refusal, plus other policies which I think are relevant, and then I have looked at the basket of policies overall, and then concluded whether the overall basket is out of date.
Yes, well,
sorry.
I know that because obviously you say so. I think it's your section 8. I'm going to come to that, but I just want to be clear. Taking each of those policies in turn, so I'll just run through them as a list.
Yeah, that's fine. Yep.
CS4, on its own, in its own terms, is it out of date?
No, in its own well, I have reduced the. I say that there are elements of it which don't reflect the approach to veteran trees in terms of the MPPF. So yes, in terms of then compliance, I do then reduce the weight to it and say that it is out of date because it doesn't reflect the requirements of the MPPF.
So you're saying CS4 is out of date, and you're saying it is out of date for the reasons that we see listed on, I think it's page 68.
It's page
of your
68.
reference. Yeah, okay. And so if I want to test whether your assertion is correct. I can do so by looking at what the MPPF says in relation to veteran trees, ask you some questions, then we'll be clear.
Well,
Good.
actually, sir, no, he can't do that because he hasn't got any evidential case.
Well,
No, let me finish, please, Mr. Leader. The only basis on which the appellant's analysis on the basket of most important policies being up to date or out of date, the only basis on which Mr. Leader's evidential case takes issue with ours is on whether CS13 goes into the basket. There's nothing in the written evidence whatsoever, and there was an opportunity for rebuttals, and the oral evidence was confined to CS13, as we've made very clear. And that's the basis on which we've approached evidence in chief. And so as a fundamental matter of procedural fairness, if there was going to be a case put that there are other aspects of the analysis which was challenged by the council, we ought to have known by now before the council closed its case. And it's improper for an advocate to put questions to a witness that form no part of his case.
Well,
so I'm very happy for the CS13 point we put to the witness, but it's improper and should not be permitted for other aspects which could have been challenged by the council evidential case and weren't, to be put by the advocate.
Well, actually, so I don't agree. The purpose of cross-examination is threefold. It is to agree, it is to falsify, and it is to probe. And I am entitled to do all of those three things in relation to my learned friend's witness, and I'm going to do so.
Well, it's certainly appropriate, I think, for you to question this witness on the evidence that they have submitted.
Yes.
So, I think...
Well, let me be...
Sorry, put your microphone on, please, Mr. Bannon.
Provided that points aren't put that... I mean, there's a reason why we have procedures and inquiries procedures. Everybody ought to know the case they have to meet. This sounds like an infringement of that basic principle. Because had the council taken issue with any aspect of the analysis of what goes in the basket or whether the components of the basket are out-to-date, up-to-date, I would have asked questions in chief.
Well, sir,
So this is an ambush.
no, it's not an ambush, so let me help in this way. I can hardly read a crystal ball when it comes to working out what it is going to be in my learned friend's evidence. I am here to test my learned friend's evidence, and whilst I get some hints here and there from their statement of case, I see their full case set out in their proof. I'm entitled to explore their proof, and so had I known what their full statement of case was going to be in the event set out in the proof, it might have been possible to deal with things with more particularity. However, I'm not going to waste time debating what I may or may not ask. I'm going to ask the questions, and it's straightforward, really. Either Mrs. Benton can answer the questions or she doesn't have to. Fine, but I'm going to get on with it.
Well, as I said a moment ago, I understand the point you're making, obviously, Mr. Bannon, but the questioning as I'm seeing it at the minute is based on what I read in Mrs. Bentham's evidence, and therefore I think it's quite appropriate for Mr. Leader to question those aspects of that evidence.
I put my marker down, sir, and I'm sure you'll pick up if you think that the questioning is appropriate.
Well, yes, absolutely, sir. Please stop me. Mrs. Benton, just for the record...
Can I just clarify, so it's Ventham, not Ventham?
Oh, I do beg your pardon.
Okay.
Mrs. Bentham. Mrs. Bentham, if we look at CS4...
Yes.
And then compare notes on reasons for refusal, we can see, can't we, if we go back to your page 4, paragraph 1.11.
Oops, sorry, can you just bear with me?
Yeah, sure. This is going to take longer than I thought.
It's okay, it's just what was it, sorry, sir? Paragraph 1.4?
1.11, your page 4.
Yes.
You note that we say the scheme was contrary to CS4 or is contrary to CS4.
Correct.
What did you think that meant?
That the scheme is contrary to policy CS4, that it doesn't, that in your view the scheme doesn't meet
yes,
CS4?
Quite. And in citing policy CS4, did you form a view as to whether the council considered the policy to be up to date or out of date?
Did I form a view as to whether the council considered
yes.
it? No, I formed my view as to whether I considered it to be up to date.
Yes.
When I
as you read Mr. Muston's evidence, did you perceive him to consider CS4 to be out of date?
No, he does
No.
not consider
So
CS4.
there we have a difference between us, don't
Yes,
we?
we do.
We say it's up to date, you say it's not. Now, help me with this, because my learned friend interrupted at this point, but let's just nail it, shall we? If we go back to your table, on page 68, and we look at CS4, this is the point where I think I was interrupted, you identify aspects related to veteran teas as not reflecting the NPPF. Am I right in thinking that that is your compendious view as the extent to which CS4 is out of date?
Yes, yes,
Good. Now we see that you find CS5 is up to date.
correct.
If we then go to CS13, you say that's not up to date because it's not based on an NPF compliant assessment of local housing need.
Correct.
That's the extent of your concern as to whether that policy is up to date. Nothing else?
No, that's a fundamental concern.
Good.
from my perspective.
Now then, CS14, you tell us, you give us some reasons why you say that that policy is not up to date. Just pausing there. Just give me a second.
Are you turning to CS14?
I may do in just a moment, if you'll just give me a second. Yeah. CS14 doesn't actually set settlement boundaries, does it?
It talks about, it then cross-references to the policies. The settlement boundaries aren't set through this plan. In any case, obviously,
No, they're not, are they? So just thinking about it,
what CS14 does do is obviously it sets out the locational distribution of development.
yes, it does. That's correct. It does do that. And what it doesn't do, as you've just said, is set out settlement boundaries.
Yeah, and what it says, if you just bear with me, at the fifth
Can
paragraph.
I just
Sorry.
pause you there? Because if we go into the policy itself, I really want to be checking that. So.
You are, sir. So you need to go. I think it's divided D1.
Yeah, D1, I've got CS13 on
And you'll
page
need page
65, 67, CS14. Okay, thank you.
Now, as we look at that policy together, you're right, it does indicate a settlement hierarchy and a sustainable development strategy based upon it.
Yes.
What it tells us, in I think it's the fifth paragraph, is that settlement boundaries define the area within which residential development is acceptable in principle. What this plan doesn't do is tell us where those settlement boundaries are.
No, that's correct.
Right. So as I go to your page 69 and your commentary on CS14, you say this: no, the housing requirement is not based upon an NPPF compliant assessment of local housing need, and the settlement boundaries are out of date. Right. Taking that in stages. As I read your comment on CS13, I thought the first part of that observation was related to CS13, not CS14. What CS14 does is talk about distribution. It doesn't set numbers.
It doesn't set numbers, but it talks about the, it's a distribution of development that is set out to deliver the 28,985 under policy CS13. So it's a distribution strategy to distribute CS13.
So, just looking at your commentary, we've agreed, I think, that CS14 doesn't set settlement boundaries. I don't understand why you say CS14 is out of date. Can you sum it up in a sentence?
Because CS14 is distributing the housing related to CS13, and therefore CS13 is not based on a compliant assessment of local housing need, and therefore, in my view, CS14 is inherently linked to the delivery of CS13. If you can just bear with me, so as well, I think that And amongst some of the appeal decisions that the council have put into the core documents, there are other inspectors who have also found, drawn similar conclusions in respect of CS14.
Yeah, just pausing there. If you want to refer to any of those, by all means do so now, please.
Okay, that's what I just said. I just said if you just bear with me, that's...
Yeah.
Am I going to need one of the core document folders with appeal decisions in?
Yeah, I'm just trying to find... Sorry, I'm just trying to find which one it is. Yeah, so I think if I turn to, if you just bear with me, I'm just going to...
Yeah.
What I was thinking of... Yeah, the one I was thinking of in particular is it's core document, it's CDF 13.
F13.
F13.
Bear with. I've got mine set out slightly differently, so I'm in a different one here. F13.
Yes. So, which
There's sorry.
go on, which paragraph are you going
There's
to take us
reference
to?
in there in paragraph 38 to CS14 being out of date and the plan failing. Just bear with me. There's,
Right, yes, carry on.
I would also say that in relation to in relation to there's an appeal decision from F6, it doesn't expressly conclude that CS14 is out of date, but it does say at paragraph...
Well, hang on, before we go there,
Sorry.
let's just deal with this particular
Oh, sorry,
decision.
I thought you said carry on, so that's why.
No, that's all right. No,
Yeah, sorry,
Yeah.
F6, paragraph 10.
right, now then, let's just ask ourselves whether CS14 is an important policy in this case compared with the one you've taken us to. If we go back to the first page of the Elm Grove nursery decision, we'll see that's a decision of Inspector Moss. It's dated 16th of December 2019. It's a decision in respect of an appeal made by Gladman, who were seeking planning permission for 110 dwellings. And if we ask ourselves the question, why is it CS14 was relevant in this case? Would you like to turn to page 2 of the decision? And we see, don't we, if we read paragraph 12, as I expect you have done, we have a summary there of the way in which new housing is distributed throughout the settlement hierarchy we've looked at together in CS14.
Yep. Correct.
And if we look at if we look at paragraph 13, we see there's a discussion there of where the settlement boundary is around Locking, and we see, don't we, that the particular site that we were dealing with in Locking was outside it, or rather is outside of the settlement boundary.
Correct.
Yeah. We also know, don't we, that the site isn't allocated in the locking appeal.
Yes,
Yeah.
correct.
And we see paragraph 14, CS14 confirms that outside of settlement boundaries, the event will only be acceptable where a site is allocated in the local plan. Yeah, well, your site is allocated, isn't it?
Part of it.
Well, it's allocated,
Yes,
isn't
it
it?
is.
Yes.
It's allocated.
So you see, in the locking appeal, it was relevant, wasn't it, to consider whether CS14 was out of date, because the exception which made that issue important in the case was that the appeal site in that case was not allocated and it was outside of the settlement boundary.
Correct.
Yeah, whereas in your case, you've got a site which is allocated, albeit it's outside of the settlement boundary. Yes? Yes.
Yes, correct.
So, if one seeks any particular assistance from the locking decision, one applies the handbrake and notes the decision was concerned with a materially different set of circumstances compared with this case.
Yes.
Yes, good. Thank you very much. So, you were going to refer us to a second decision. Which was that?
No, what I was just, it's not one where, sorry, it was F6 I was looking at, and it's not one where the inspector doesn't conclude that that CS14 is out of date, but there is I would say it's part of a theme through these decisions, that there is concern that has been expressed in respect of the ability of the council to deliver its housing requirements inside of settlement boundaries, and also concern about the approach to the restrictive nature of CS14 in light of the housing requirements set out at CS13. So I think what I would say is that there's a theme of CS14 and its approach that has been expressed in previous appeal decisions.
Yes, yes. But the point I'd like to put to you, and I think
Sorry, I just want to hear,
Okay,
just mid-note there. Yes, yeah.
It's okay, I haven't finished, that's all. And what I was just going to take you to really was we talked through the SOAM decision.
we're going to come to Sohan,
Okay,
if that's all
fine.
right.
Okay.
If we could just stick to the question, otherwise we're here all day. Now, well, actually, sir, I'm going to ask about CERM later, and I did not ask a question about the CERM decision, sir. Well, I'm really indifferent, but I'm going to come to CERN in detail later. I'm flagging that up now, sir.
Okay, we'll come there, but I'd like the the complete answer to the earlier point, and if you can go back.
Okay,
Yeah.
thank you. Apologies if I've now forgotten the question, but I think the reference I was going to make to the SOAM decision is the conclusion that was drawn by the inspector in that appeal in relation to the operation of, as it was at that time, policy growth 2, which sets out that it provides the locational strategy for delivery of expected growth in the district. And I see the North Somerset Plan, policy CS14, as providing that locational strategy.
Fantastic, thank you. Now, getting back to the question I asked, the locking decision, we have agreed can be distinguished by reason of the materially different facts in that case. Namely, that in that case we're dealing with an unallocated site outside of the settlement boundary, falling with an express exception set out in CS14.
Correct.
Now, you then took me to F6, and we can agree, can't we, that insofar as you intended to go to F6 to demonstrate that there's an inspector's decision which indicates CS14 is out of date in circumstances that might be compatible with your case, you're unable to demonstrate any such finding.
Yeah, in terms
Good.
of...
Now, having
No,
agreed that,
please, yes, but, and I just want to get the but down, please.
Thank you. What I would say is that we do have to bear in mind that policy CS14, yes, it doesn't define the settlement boundaries, but under the terms of policy CS14 and under the terms of the SAP, the site allocations plan, the appeal site is sat outside the settlement boundary, because the settlement boundaries, sorry, I'm glasses up, I can't work out whether to do glasses up or glasses down, so apologies. Under the terms of policy the site allocations plan, the settlement boundaries weren't reviewed as part of that plan either. So as far as settlement boundaries, yes, my site is allocated, but it does still sit outside of the settlement boundary.
Yes, I know.
Okay.
But that's the exception that's specified in
Yes.
CS14.
Yes.
And that's how this site is different from the locking site that you
Yes,
took me to.
that's correct, yes.
Good. So then getting back to F6 and repeating the question.
Yeah.
You indicated you wish to refer to F6 because you thought it was going to assist your case by demonstrating that in analogous circumstances to that which we now found ourselves in, there was a finding of an inspector which indicated CS14 was out of date. And just for the record, I can write down, can't I, that when asked to show Mr. Leader the part of the decision which proves that proposition, the witness was unable to do
Yeah,
so.
I at that point I said that in relation to F6, I said it showed, at the time when I then went back to it, I said it showed a theme of concern, but I did agree with you at that point.
Yes, but the point is, yes.
Yes, and I said yes.
Thank you very much. Good. Now, moving on. Having dealt with CS14, we come next in the list to DM9 and looking at page 68. Happily, we see that you find that policy is up to date.
That's correct, yes.
And we also find that CS10, which is another one in your list, is up to date.
Correct, yes.
Good. Out of interest, why is that a most important policy in this appeal?
Because, well, at the time, the reason I listed that as a most important policy was because at the time it was reading the council's case at the time of the production of the statement of case. It appeared that the council were going down a route that might have been going down a route about technical compliance in terms of transportation and movement. It's then become subsequently clear through the through the exchange of evidence that the emphasis that I thought they might be taking at that point it's not the council's case. It was what I thought they were going to do from the statement of case. So you could argue that in terms of then, is that a most important policy? Well, I don't cite that CS10 is the most important policy in any case, but you know, my view is no, it's not the most important policy.
So it's not?
No.
Good. So I could strike that off the list you gave me. Thank you. And then we come to DM32.
I think, just to clarify, I didn't give you CS10, I gave you the policies that were in the reason for refusal.
Well, you did, and DM10 is in the reason for refusal.
You just said CS10,
No,
sorry.
I just said DM10.
See, I've noted CS10
Oh, did
here.
I? Well, then that's
That's
very
very
bad.
sorry. I think that's...
Yes.
Well, I did
CS10
also-
transportation and movement is
Yeah.
what I was
Oh,
thinking
I beg
the
your pardon.
answer
It
was.
is CS10. What's
Yeah.
the matter with you?
Yeah.
So
So-
we've just talked about CS10.
We just, yeah, so
And
what
we've
I'm-
agreed.
We've agreed, and it's in my table that it's not.
Thank you very
important
much.
policy. Sorry.
Good. No, my fault entirely. So
Okay.
we struck it off the list in any event. Now,
Well, no, yeah, I was going to say, it wasn't, yeah.
yeah. Finally, DM32. Well, we're going to come to SA1 as well, but DM32.
Yeah.
Is that the same point as the CS14 point, in essence?
In terms of, yeah, I mean, in terms of, sorry, can you clarify what you mean by that question?
Well, as I look at the reason why you've said the policy is not up to date, yeah, it looks similar to the reason that you gave for CS14.
Sorry, are you
Yeah.
talking DM32 or CS32?
No, CS32.
Sorry, then you said DM32.
Yeah, I'm sorry, you did say DM32.
Yeah, so I
I
think-
turned over to DM32.
I think I probably need another copy. in any
So
event.
we're on CS32, are we?
CS32.
Okay, yeah.
So,
Yes,
right,
sorry.
CS32,
Yep.
you've got a comment there, which is no, strategy and distribution not based on up-to-date local housing need figure, yeah? Now, insofar as CS32 is identified in this table, I think I'm right in saying two things. First, you don't think it's one of the most important policies in this appeal.
I do. I say in that CS32, I have...
Well, the reason I'm asking you the question is, and I hope I heard you correctly, if I didn't, the inspector or Mr. Banwell both will correct me, is that when you gave me a list of those policies which you said are the most important, at the start of your cross-examination, that wasn't one I noted. I noted DM32.
I did, yeah.
Yes, but then I asked her to run through the list, if you recall, Mr. Banner, and I took down a note of what was in her list, and the list did not include CS32. Does it now?
It does, because it's in my evidence as CS32, so...
Yes, yes, but you appreciate that when I ask you a question, the question is intended to clarify and reduce your evidence down into bite-sized chunks for my
but that was
testing. So when I asked you that question and you didn't tell me CS32, should I have written CS32 down?
Yes.
Very
I think my evidence is pretty clear, and I think it was open to you to have checked at that point whether I'd missed something off.
I don't have to check.
No,
I just rely upon your answers, you see. So having received the answer, which did not include CS32, I've now noted it does, and pursuing that point, I observe that what you say about CS32, in terms of the question of whether or not it's up to date, bears a striking resemblance to what's said about CS14.
Correct.
Is it essentially the same point?
It's the same approach, yes.
Good.
You know, it's the same approach. Obviously, the final part of CS32, out with the bullets, says sites outside the settlement boundary in excess of 25 dwellings must be brought forward as allocation through local plans or neighbourhood plans, and it relates back to the same points.
Right. So let's just look at that together. So it's D1.
Yeah, D1, page 130.
130, thank you.
Right. So tell me, as I read CS32, which bits are out of date, or to what extent is the policy as a whole out of date? As I read what's here, as opposed to what I read on page 69 of your proof.
Again, it's the same point, but I would say about the settlement boundaries are effectively, in my opinion, out of date, which therefore, because obviously you've got the starting parameter of policy CS32, which is new development within or adjoining the settlement boundaries, and it's my opinion that the settlement boundaries are out of date, and then there is reference at the end to sites outside of the settlement boundaries being brought forward as allocations through local plans or neighbourhood plans, but it's my view that those settlement boundaries are out of date.
Well, I'm just trying to work out how this is at all relevant to this appeal, because of course your site has been allocated, and CS32 is about new development, specifically applications for new development, in service villages. Well, on unallocated sites.
Correct.
Yeah.
Well,
yours is an allocated site.
Well, it's not just about, it does, I mean, well, it depends on your reading of it, because I would say, okay, well, actually, if I look at CS32, obviously, that there is a reference there to sites outside the settlement boundaries being brought forward as allocations, which is the case for this site. So there is a relevance. It's a housing policy which has a relevance to the consideration of this appeal scheme.
Well, I mean, I've heard what you've said. I'm going to have to make submissions on it, but what I'd like to put to you is that CS32 is plainly intended to be a policy which helps the decision maker identify sites that will be suitable for the scale of development identified by this policy. That's its purpose, isn't it?
Yes, but within that, there is, as I said, there is reference to sites of the scale of the appeal scheme being brought forward as allocation. So there is a relevance to the consideration of the appeal scheme in that policy.
Well, I'm just wondering why it's a most important policy in this case, as opposed to a policy which one might say has some sort of bearing on the appeal. But why is it an important policy?
Because I am dealing with a housing allocation on a site in excess of 25 dwellings in a service village.
So what?
So what? It's a relevant, in my opinion, it's a relevant, important policy to take into consideration.
Well, that's your answer. Fair enough. I have to say I'm wondering why it is relevant, but there we go. All right. Well, most important, I should say. Now, going back to the list, the last one you gave me was DM32. And in what respect you say that is, well, you say it's up to date, good.
Yes,
so
it is.
DM32 is up to date. Now, are there any other policies which you say are most important, which we haven't canvassed to try and work out why they might be out of date if you say they are?
Not outside of this table.
Well,
I mean, I
do you
deal
say
with
the whole table is to be regarded as containing policies which are out of date, rather is every policy in this table A, out of date, or B, most important?
No, I set out what I consider to be the most important policies,
Yeah.
and then, as I said, I then put those policies into my basket and conclude whether or not the basket as a whole is out of date.
So you're suggesting that every single one of these policies, I mean you are, because it says yes in every case, you're suggesting, except for DM71 and DM70. Crikey.
No,
Well,
I'm saying the third column says most important policy, and I've
Yeah.
written yes or no. So I'm not saying that DM19, DM24, DM36, DM48, DM70, DM71, CS9, CS10. I'm not saying those are most important policies.
Okay. Well, let's press on. I think I understand. I'm struggling to work out why some of them are most important. We'll probably deal with it when we go to each policy in turn. All right. Good. Shall we start with SA1?
SA1, did you say?
Yeah, let's go to SA1.
Just bear with
So
me.
SA1 is in D3. And as you told us earlier, we need to go to page 14.
I'm sorry, Mr. Lear, I'm just wondering, we're approaching 25 past 11. If you're just starting off on SA1, might
Well,
that be an appropriate
I think
point?
you probably would say, yes.
I was going to say, if you have a 20-minute or so mid-morning break now, is everyone content with that? Yes, looks
And
to
so I
be.
have to say my time estimate, which I think was 2 hours, is going to be well exceeded.
Well, we've got. Have we got any restrictions on this room today? No. Okay. Well, we will press on. Let's adjourn till 11:45. That's a 20-minute break. People, time for a coffee, etc. So I'll adjourn now. We'll resume at 11:45. Thank you. Well, the inquiry is resumed, ladies and gentlemen. Mr. Leader, have you got an indication for me as to how much longer you think? You said your estimate may be exceeded, but just so I can keep tabs.
So it's very difficult to say. I had intended to be about an hour and a half, and I've had that already, and I haven't really got
Well,
very far.
what have you had so far? You've not had that long, have you?
It feels like I have.
We started at 10:45, didn't we? 10:45 to 11:25. You had, what's that, 40 minutes?
All right. Well, sir, I'm going to be done by lunchtime, come what may.
Okay.
If I haven't finished by then, I probably ought to be shot. Right. So, with that in mind, we'd better make some good progress. Now, if we could turn please, to the site allocations plan, which is at D3, and page 10, we see there the start of the detailed policies on housing. On page 11 is the start. Page 10 faces. And we turn over the page 14, and we see policy SA1, and we read what it says: residential sites of 10 or more units are shown on the policies map and set out at Schedule 1, together with any specific site-related requirements or key considerations to take into account. Now, a plan comprises of two sorts of text, doesn't it? It comprises policies and it comprises reasoned justification.
Correct. Yes.
Agreed?
Yes.
And as we read policy SA1, we can see quite clearly that it refers to two things. First of all, a policies map,
Correct.
and secondly, a schedule, Schedule 1.
Yes.
Now, what we can also agree is that if we then turn to Schedule 1, and it's page 52, I think, the part that deals with the appeal site, if we ask ourselves the question, where is the written justification to policy SA1, it's clearly, isn't it, that part of the written text that sits above policy SA1 on page 14 of the plan. It's not what we see at Schedule 1.
Sorry, can you just repeat that? Sorry, can
Yeah,
you just
go
repeat
back to page 14. You'll see policy SA1 set out at the foot of the page.
Correct,
Yeah?
yep.
And if one asks the question, well, where's the reason justification for that policy?
Yep.
It's set out above policy SA1, isn't it? That's the format of this part of the plan. You have reason justification, and then you have policy at the foot of it.
Yes.
Yes.
Sorry, I understand the point.
So if we ask the question, where's the reason justification to policy SA1, it's above policy SA1, the text that we see preceding it. Yeah?
That's the way that the plan is
Thank
set
you.
out in that part.
So
yes.
then, flicking back to page 52, we know when we get to page 52, we are dealing with something that's referenced expressly in the policy, because we noted a moment ago it referred to Schedule 1.
Correct.
So when we look at Schedule 1, we think, right, that's referred to in the policy, and we know it's not reasoned justification, because we've agreed that the reasoned justification is what sits above policy SA1.
We agreed that the reason the reason justification sat above policy SA1. I don't think I necessarily agreed that there wasn't reason justification further into the plan as well. You just asked me whether...
No, that's true. But Schedule 1 referred to in the policy itself, it's quite common, isn't it, that when one sees site allocations set out in local plans, you have a policy which then contains, within the policy, particular guidance on the way in which a site is to be developed. You'll be familiar with that approach, as will the inspector.
Yes.
And so what we have here in Schedule 1 is same approach, but presented slightly differently. Instead of having a plan which lists a series of sites, such as Moor Road in Yatton, and then page after page of uppercase policies, we have a single short policy which then incorporates by reference what is in Schedule 1. That's right, isn't it?
Yes, but I think your point on, that we will often see policies which then contain the guidance, that guidance is then contained within the policy. What we haven't got here is the guidance or the guidance contained within the policy box. Now, I take your point, obviously Schedule 1 is extensive, but there was, it is very clearly written in a different way to Policy 1.
Well, can I just seek to agree with this? Because at the end of the day, as my learned friend said, this is going to be a matter of submission. What we see on page 52 is part of Schedule 1, and I think you agreed with me that Schedule 1 is incorporated into Policy SA1 by reference.
Yeah, there's reference within Policy SA1 to Schedule 1.
Yeah, it's incorporated expressly by reference.
There is reference to it.
Do you agree with the whole of that question I put to you?
No,
It's
no,
incorporated expressly
No,
by
I don't think it's
reference.
incorporated expressly. I think there is reference to Schedule 1 within Policy SA1, but I think, it's very clear that Schedule 1 is set out distinct from Policy SA1.
Well, all right, I mean, at the end of the day, so I can make submissions on the nuance between us. Now, just proceeding on the basis that Schedule 1 is part of the policy, I accept you don't agree with that proposition, but let's just proceed
Go
on
forward
that
on that
basis.
premise, okay?
Where we are in disagreement is as to whether or not the appeal proposals satisfy the provisions of the fourth paragraph of the schedule to SA1.
That's correct.
Now, let's just take this in stages. The first point is this. The appeal proposals, as I understand it, are set out in, amongst other things, drawings Y12, Y13 and Y14. Those drawings detail the landscaping proposals, the planting scheme and the planting plan. That's right, isn't it?
Insofar as it relates to the road, yes.
Yes, quite. Yeah. So insofar as Natural England are interested in this proposal, they're interested in drawings Y12, Y13 and Y14, and we know that because, of course, they were consulted on those drawings by the appellant and the council.
Yep.
And they are being consulted on those drawings by the appellant and the council.
And the council again, yes.
And the reason they're being consulted on those drawings is that the drawings that they had been consulted on have been superseded.
They have. Obviously, what I would also say is that, as we've talked about in the draft planning conditions, and we'll come on to those, but obviously the draft planning conditions allowed for that eventuality in any case.
Yes.
But,
yes.
Yeah.
But the scheme that they had no objection to has been superseded.
but the can I?
Yeah, please do.
But the parts that that Natural England are, in my reading, and obviously this is probably a matter for the ecologists, but my reading of the Natural England response is that the parts of the scheme that they refer to are unaffected, other than getting better, unaffected by other than an improvement by the current scheme. But so as it currently stands, the position is, one of no objection from Natural England. Clearly, they are being reconsulted, but as far as I'm concerned, the scheme is currently subject to no objection from Natural England.
Well, let's just take it in stages.
Okay.
I understood you to agree with me when I put it to you quite simply that the scheme that Natural England had no objection to has been superseded. It's no longer part of the appeal proposals, is it?
No, not the one that Natural England Yeah, not the ones
Good.
that Natural England responded to. Y12 to Y14 are
Yeah.
subject to amendment.
Quite. So having disposed of the December 2018 and December 2019 versions of Y12, Y13 and Y14, we've now presented to Natural England drawings dated February 2022, bearing the same
yes.
numbers.
Correct.
And you'll have seen the email that Natural England sent to the inquiry last week, which indicated it wishes to be consulted on those drawings.
Yes, and obviously you'll appreciate that we had no input into the email that went
I know
to
that,
Natural England.
but that's Natural England's formal position as recorded in an email presented to this inquiry.
Yep, that's correct. But obviously what I would also flag is that as part of that, the council themselves, I know you yourself accepted that what we were putting together as far as a plan was a materially better plan.
The council hasn't agreed that. Let's move on. Natural England having indicated they wish to be consulted, it's right, isn't it, that because they haven't been consulted and therefore we don't know what their response is.
I think...
Well, hang on, just let me ask the question.
Oh, sorry, I thought
now
it
you're
was a question.
doing what I do. Because they haven't yet been consulted, as far as I'm aware, and certainly haven't provided an answer, we cannot at this stage record, can we, that they agree that a suitable scheme will be put in place by the appellant to accommodate the access road.
The current scheme that the current response from Natural England, yes, the current response to the planning to the appeal scheme as a whole from Natural England is one of no objection. Yes, the plan has been tweaked, but not, in my view, in a way which would affect the outcome of what Natural England are likely to say. And as I said, bear in mind that those amendments that we have sought are solely beneficial. There is extra tree planting and removal of a path. And as I said, that is also facilitated by conditions Y12 to by the draft planning conditions, which also allow for the substitution of amended plans.
Whether the scheme is better or not will be established in due course by the examination of the ecologists if they can't agree.
Correct.
You're not here to provide evidence on ecology as I understand it, so just sticking with the question rather than trying to foretell the future, the position as of today is that you have replaced the scheme to which Natural England had no objection with another scheme, and we're waiting to see whether or not, in the terms of policy SA1, it is agreed. As a matter of fact, that is right, isn't it?
That is correct, but obviously the outstanding, the current consultation response from Natural England is one of no objection, subject to us fulfilling their requirements.
So, as of today, we can agree that insofar as a suitable scheme has to be agreed, such agreement is not before the inquiry.
No, not in terms of the amended plans. What I would, well, yeah.
You don't need to keep repeating your answer, but the inspector has heard your answer.
I think,
he can form his own view.
I mean, my view, and again, it might come to this point where we have to recall the planners. But my view would be, I would expect that by the time we get to the end of this inquiry, bearing in mind I would normally go last, is that we will be back in the position of having that plan agreed with Natural England.
And if it's not agreed, we can agree between us that policy SA1 will not be satisfied.
No, not the whole of the policy would not be satisfied. We'd have a breach of one bullet of the criteria to be taken into account.
Well, it's a pretty fundamental clause of the policy, isn't it?
Well, you could also say that any clause in there is fundamental. Clearly, contribution to a comprehensive surface water drainage strategy. If my site were to flood, which it doesn't, that would also be a pretty fundamental clause.
Well, it would, but you're not seriously suggesting, are you, that non-compliance with the fourth paragraph that we are now looking at is a matter which could be set to one side as of little importance when trying to establish whether a scheme complies with this policy?
Well, I believe that it's the council's case. Mr. Muston agreed that it wasn't do or, I think the phrase was do or die. in relation to that. So it's the council's own case that the compliance with the development plan doesn't rise and fall on the breach of that criteria.
That wasn't the question. I was asking you about the policy, not compliance with the plan as a whole. We'll come to that.
Okay, compliance with that policy, in my view, doesn't rise and fall on the breach of one of 10 criteria.
Well, if that's your evidence, fine. We've agreed that you don't presently have Natural England's agreement to the scheme as amended, but you're rather expecting they will agree. We'll see. Now then, let's turn to the further issue as to whether or not alternative access arrangements can be made. Now, taking Grange Farm Road first. It's right, isn't it, because Mr. Mansell, I think, told us this, that there's no technical difficulty in providing a scheme of access from Grange Farm Road. And by technical, I mean engineering. That's right, isn't it?
That's correct, yes.
Yeah. There is an issue, you would say, as to whether or not access can actually be provided because you don't control the strip of land that lies between the fence and the end of the adopted highway.
That's correct, yes.
Yeah. Now, do you happen to have a copy of the NPPF in front of you? Or if you don't, perhaps you could just pick one up.
Just bear with. I do.
And if you wouldn't mind just turning to...
Sorry, if you just bear with me. Oh, yeah, sorry.
Yeah. Page 66. Now, before we go to the words on page 66, let me ask you some preliminary questions, if I may. First of all, do you agree that when it comes to the question of whether or not a site is deliverable, one is not concerned with the question of whether it's deliverable by a particular individual or developer? The question is, a broader question, is a site likely to be deliverable by anybody interested in development?
Yeah, it's not specific to a...
No, quite. Having agreed that, let's look at what deliverable is defined as being. Deliverable. To be considered deliverable, sites for housing should be available now, offer a suitable location for development now, and be achievable with a realistic prospect that housing will be delivered on the site within 5 years. And then it continues, but we can just pause there. Now, we can agree, can't we, that the site is a suitable location for development now, because the local plan says so.
Yeah, that's correct.
And the question as to whether the site is available for housing now can also be answered in the affirmative, because of course we have Persimmon seeking planning permission at this appeal, but we also know the owner of the land is keen to dispose of it for development.
The owner of the appeal site, yeah.
Yes. So the owner's keen to sell for development, we know that, because they've given Persimmon an option, and here are Persimmon wanting to develop it too. So the site's available now, and it's a suitable location for development now. The question that arises is, will development be achievable with a realistic prospect that housing will be delivered on the site within 5 years? That's the issue.
Well, so again, I'm afraid I am going to intervene because we've been through this, and it's been, the council's accepted it's not deliverable because we went through the 5-year supply. So it's not in its 5-year supply, which is an assessment of the sites that are and aren't deliverable. And I asked very clear questions, got very, very clear answers from Mr. Munstead on this. This, I think, to be fair, does overstretch the line, because now the advocate is putting a point, i.e. that the site is deliverable, which is actually not just not a point made by his witness, but actually flatly contrary both to the council's formal assessment of 5-year supply, which the public are entitled to rely upon, and also contrary to very explicit responses by his planning witness. So this is, I do formally object to this and ask for a ruling if we have to.
Well, yes, I mean, I've certainly got notes and the response that Mr Muston has given previously as to how the council views this site. So I'm not quite sure how...
Well, so I think if we look at Mr Muston's evidence, and we can if you like, Mr Muston has indicated that he believes this site can be developed now by persons other than Persimmon. And what I'm seeking to do is explore that point with this witness. And I have to say, whilst I understand my learned friend's approach, I do find this repeated interruption of what appear to me to be perfectly reasonable questions to be, well, unfair. And I'm going to persist with this line of questioning, so unless you instruct me that I may not.
But I'd like to just respond to
Well-
because Mr Leader has mischaracterised Mr Munson. He doesn't say the site is suitable now. We've had a 5-year housing and supply session testing the council's position on which sites are and aren't livable now. The appeal site is omitted from that, as you well know, sir, and as Mr Leader well knows. Further, I asked Mr Munster in cross-examination, we all got our notes of this, we can't pretend it didn't happen, Mr Leader. We got very, very clearly, he wasn't re-examined on this either. Is it accepted that if the appeal is dismissed, this site won't come forward within the lifetime of the SAP? And he accepted that absolutely explicitly. So this is not me, I don't normally intervene in cross-examination, but I do when something completely out of order is happening, which is what is happening now.
Yes, it does seem, on reflection, that your line of questioning on this particular point, Mr Leader, is going contrary to notes that I've got from what your witness has said earlier and hasn't been, as it were, re-examined on.
Well, sir, I'm not entitled to examine a witness in re-examination to produce an exact opposite answer to that which he gave in cross-examination. What I am entitled to do is put my case. My case is that the land is owned by another developer and that if this appeal is dismissed, another developer will deliver the site. If you'd like me to turn up Mr Muston's evidence, I will do so, and I'm entitled to put that. I'm not arguing about whether the site is deliverable or not per se. I'm arguing about whether another developer would be able to access this site if Persimmon do not. There are further points I'm going to put, sir, but I'm entitled to do so, and I intend to do so unless you tell me I can't.
No.
Well, sir, can I just come back on that? Because I'm afraid there is a bit of elision here.
Okay.
I'm very happy for that point to be put, provided it's on the basis that it will happen after 2026.
I'm going to
The
put
time
my
scale. No,
case
Mr. Miller,
as
please.
I wish.
No, Mr. Lee, please don't interrupt. Because the very clear evidence on time scale is that irrespective of developer, if the appeal is dismissed, it won't happen in the 5-year supply period. And that is, to unpick that now, frankly, we'd have to recall the 5-year supply evidence, the planners. We'd add extra time and there'd obviously be an inexorable application for costs. And I'd say it's inappropriate in principle. If the point is, well, at some point in the future, beyond the 5 years, somebody might develop the site, no problem. But Mr. Leader says deliverable now, and he used the word now, if you remember a moment
Actually,
ago.
I didn't. I said 5 years.
Well,
Mr.
let's go back and watch it on YouTube, Mr. Leader.
Well, shall we just get on with the answering of questions?
Well,
Because,
I think we're going to have to, but I'm going to have to obviously take it in the context of matters that have already been, as I thought, resolved and agreed through the likes of the Housing Land Roundtable session. I mean, well, all we can do is proceed. I'll hear the points, and really I'll have to leave it to the advocates to decide whether or not, on the basis of that, there is any need to recall any of the earlier witnesses and that.
sometimes it's just a good idea to listen to the questions and see where we go.
Well, let's
not really had a chance
proceed.
to put them yet.
Let's proceed on that basis at the minute
Shall we
then.
just try
Yeah.
and see what happens? Right. So, having just looked at what the NPPF says, we see that what the NPPF considers to be deliverable is, amongst other things, a site which is achievable with a realistic prospect that housing will be delivered on the site within 5 years. Yeah?
That's correct,
Just
yes.
says that. Right,
Yep.
good. Now, you've agreed with me that the question is not whether Persimmon per se can access the site, but whether access to the site can be obtained by any developer. Yes? That determines whether it's deliverable or not, doesn't it?
Yes, but clearly, you know, that's a very Yes, that is correct, but you also have to look at, for example, and I don't know the answer to this, but hypothetically, say Persimmon have a 10-year option on this site, then in reality, Taylor Wimpey, taking over the developer, can't develop it within 5 years. So it's not as simple as just going, okay, well, actually, somebody else can turn up tomorrow and bring this site forward.
I agree. I'm not suggesting
And I think-
otherwise.
I know, I'm just putting some context to
Yeah.
the question, because otherwise, you know, it's not, as I said, it's not a simple
No.
a simple answer. And as I said, well, not to repeat the point of 5-year supply, but obviously it's the council's case, that actually the being achievable with a realistic prospect, the housing will be delivered on the site within 5 years, that is not the case. So therefore,
Well, shall I just explore that with you, and then let's just see where we go? I don't want to take this too far, but I'm just interested in your answer. As you say, Persimmon have an option, don't they?
they do, yes.
Yeah. How many years remain?
I don't know, I'm afraid.
Well, the option expires in August, doesn't it, of 2024?
I said to you, I don't know, I'm afraid.
Have you not read it?
No, I haven't read the option agreement, no.
Oh, okay. Well,
And I don't, but again, it comes back, I don't think the council have put the case forward about Persimmon's option.
I'm not putting any case forward. I'm simply seeking to establish certain facts.
And what I don't know, for example, again, without delving into the detail and you know, we have
Well,
to
you-
put a note on it. Could I finish?
Yeah.
Is that I don't know whether there's a option to extend beyond that, for example. So
Don't you?
No, I said I haven't seen the option.
Well, if you're going to talk about options, and you brought the topic up, I didn't, it's probably best to have read it first.
It is, but I used it as an example, and as I said, you know, we have to take this in the context of it is the council's own case that this site is not deliverable in the next 5 years. That's in the housing. It's in the housing trajectory, or it's what's out of the housing 5 years.
You don't know when the option expires?
No, I don't
No.
know when the option.
All right. Do you know how an option works?
I do know how an option works.
Yes. So if planning permission were to be refused, what would Persimmon's options be?
They may well decide to go and talk again to the charity that own the site. They've got. They could walk away. They could go and talk to the charity again.
Yeah. So the way it works is that at some point the option expires, and until that date, Persimmon do have a right to exercise their option if they wish to.
They do. Yes.
Yeah. Okay. Now, let us assume planning permission's refused.
Okay.
Okay. Persimmon then, as we've just discussed, have a right to walk away, don't they?
They
can
do. They also have a right to continue negotiations. And
They have a right to wait until the end of the option period, and then they can see whether or not the owner will grant them a fresh option.
yes.
Now, when the option period expires, it's right to observe, isn't it, that there is a national house builder with the ability to access the site because they've retained the land, and that's Taylor Wimpey.
Yes. There is. There is.
Yes. So if one asks the question, and to take Mr. Banner's approach, after the end of the site allocations plan period, is there a realistic prospect that somebody else could access the site, never mind the rest of the deliverability test, but access the site? The answer is, well, yes, because a national house builder controls the ransom strip.
At some point in the future, yes.
Yes.
Somebody else.
Yeah. And you saw the adoption plan this morning,
Correct. Yeah.
and the adoption plan indicates that when the estate as a whole had its estate roads adopted, it was plainly within the minds of those who secured the adoption of those roads that the Grange Farm Road cul-de-sac would at some point in the future be an alternative means of access to the appeal site.
Could, not would. It says potential
Yeah.
future access on it.
Well, all right.
And you know, you would have to say that at that point it was it's a shame the council didn't seek to adopt the roads up to
Well,
the edge of the site.
Have you, out of interest, asked Taylor Wimpey whether you could access the appeal site via Grange Farm Road?
Me personally, no.
Has Persimmon?
There have been discussions in the past with Taylor Wimpey, but no, there is no agreement between the two parties.
Well,
hence,
let's... Now,
hence, can I just say, hence, there is, you know, there is nothing in my evidence about that.
I just want to unpack that.
Okay.
Do you have direct knowledge of any particular discussions between, on the one hand, Persimmon, and the other hand, Taylor Wimpey or Bryant Homes?
No.
No. So what you have just said about you're aware of discussions in the past. What discussions, when, between whom?
That's why I said I haven't put it in my evidence. All I
Well,
know.
no, you haven't.
No.
So you said what you said. I want to understand the factual basis upon which you said what you said.
I haven't been party to those discussions, so I don't know the details of them.
You say you haven't been part of those discussions.
No.
Which discussions?
I haven't been party to any discussions in the past between Persimmon Homes and Taylor Wimpey in respect of that, the access through Grange Farm Road, so I can't add anything to that discussion.
Can we be more precise? You are not aware of any discussions that have been had between Taylor Wimpey or Bryant Homes and Persimmon, are you?
I'm not aware of the detail of any discussions, no.
When you say not aware of the detail, you're not aware of any, are you?
Any detail, no.
Do you know when any discussions might have taken place?
No.
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 So essentially, I think what you're telling me is you are not aware of any discussions that have ever been had between Bryant Homes, Taylor Wimpey and Persimmon.
No, what I'm saying, again, is I'm not aware of the detail of any discussions.
Right. So what are you aware of then?
I'm aware that there have been discussions, but I don't know the detail of them. I haven't been involved with any of them.
So if I said to you, can you produce me a letter or an email or the note of a telephone conversation which indicates within the last 3 years there's been any approach by Persimmon to Taylor Wimpey or Bryant Homes canvassing the possibility of their taking access across the Grange Farm Road cul-de-sac, you're unable to assist, are you?
No, I can't assist, no.
Well, don't you think it's quite relevant, given the council's case, to have at least asked the question, have Persimmon asked Taylor Wimpey or Bryant Homes whether they may use the Grange Farm access?
Well, the starting point is it's outside of the control of Persimmon.
Yes.
So it is third-party land.
That's why they'd have to ask.
May I finish?
Yes.
You yourself have indicated in your opening submissions it may be that there is a ransom strip there. And I would also say that in the officer's report to Planning Committee, as I've dealt with, the discussions that went on about the potential for alternative access points, my understanding is that the discussions included both parties.
Well, your understanding based upon what?
Well, based on the wording in the officer's report to Planning Committee, where it talks about alternative accesses, it says there's reference to officers having meetings, there's references to alternative access options being thoroughly investigated.
Yes.
That would suggest that this hasn't been the decision not to come through, or the inability, not to come through Grange Farm, hasn't been solely dictated by Persimmon. It's also involved officers.
Well, I don't think Mr. Muston was asked, actually, whether there'd been any discussions with Bryant Homes or Taylor Wimpey, but I'm sure I'll be corrected if I'm wrong. Now, let's just pursue the matter a little further, then we can stop. You observe, and I think as you say in opening, I readily concede, that the land which is controlled by Taylor Wimpey Bryant Homes would customarily be described, I think, as a ransom strip.
Yes.
They'd obviously expect some money for gaining access across that land.
Yes, correct.
Your evidence doesn't demonstrate, first of all, that you've asked how much they would ask for access across that land, or secondly, that if access were to be taken across that land, the appeal proposals would not be viable.
That's correct. Yes, my evidence doesn't show that. That's correct.
Yeah. Thank you. So, what we can agree is the question of whether or not access might be obtained from Grange Farm Road in collaboration with Taylor Wimpey, and by collaboration I mean paying some money, is not a matter the appellants sought to explore at all, at least not so far as you're aware.
Correct, yes.
Good. Thank you. Now, if one then returns to policy SA1, on page 52, and reads the words, if alternative access arrangements cannot be made. If alternative access arrangements cannot be made. Don't you think those words connote making an effort to make alternative access arrangements?
In terms of the phrase cannot be made, we discussed this, or Mr. Mustin discussed this, and I think he concluded that cannot be made could probably only relate to land ownership, because there is always 9 times out of 10, there is a technical solution that can be found. So, cannot be made. In my view, we cannot make an access because there is a third-party landowner in the way of the edge of the adopted highway and the appeal site.
Yeah. Let's explore that together just for a moment. Okay. You've agreed you haven't any knowledge of anybody asking whether Taylor Wimpey would allow you access across the ransom strip. And you've agreed with me that there's no evidence that were such access to be obtained, the site would not be viable. So let's just go back to the question I'm asking you, interesting though your other observations were. I put it to you that the words will only be considered if alternative access arrangements cannot be made, connote making an effort to secure alternative access arrangements. I'm putting that to you very directly. Perhaps you could give me a direct answer. Does it involve making an effort or not?
That's not what the policy says. It says, can I make an access there? No, I can't make an access there. There is a third-party landowner.
Would you like to answer the question?
I said no.
Well, so your answer to my question is, as I understand it, I put it to you that those words connote making an effort to secure alternative access arrangements, and you're saying no effort's required at all.
No, I can't make an access there. There is a third-party landowner in the way.
Yes, there is, isn't there?
Yes.
But of course what you can do by making an effort is say, excuse me, Taylor Wimpey, if I pay you some money, may I come in via Grange Farm Road, please? You could do that, couldn't you?
I could, but...
Yeah.
But from my perspective, if, as I believe I can, demonstrate an alternative access, which in my view doesn't cause harm, then why should I be paying another developer an unspecified amount of money to form an access?
Well, there's two reasons I'd put to you. The first is that the policy tells you should make alternative access arrangements if you can. That's what it says in terms. And then secondly, the reason you should do it is because actually you'd be able to get on with your development nice and quickly, wouldn't you?
Not if the sum of money is so large that it prevents the development coming forward, then I can't get on with it nice and quickly at all. It will not allow me to get on and build the site quickly.
If that were to be the case, if you'd asked, that would be a fair response. But you haven't asked, therefore that's not a suitable response, is it?
Well, no, because it's unknown, isn't it? As I said, the council themselves acknowledge it may be a ransom strip.
It is a ransom strip.
Yeah.
And the answer to the question, could you come across it, is unknown because you haven't asked. We've been there. Now, you told me earlier, after referring to the option agreement, you hadn't read it.
No,
so you won't know what's in Schedule 6. I
used a hypothetical scenario. I didn't refer to the Persimmon option agreement. I used a hypothetical scenario of an option agreement. So no, I haven't seen Schedule 6. I make no reference to it in my evidence.
No, that's fair, and nor does Mr. Muston.
No.
But I am sure we'll be looking at it when we come to talk about the 106.
I'm sorry?
And,
I didn't
I'm
hear
sure
you.
we'll be looking. Well, I'm sure we'll look at it later.
Okay.
I think I've gone as far as I can on SA1. Good. Now then, Right. I've got half an hour left, so let's change the topic slightly. CS13.
Sorry, just... Can I put the...
Yes.
That policy?
Yes, please do. Now, the SOAM decision. As I understand the point of the SOAM decision being brought before this inquiry, it is to show that when a local authority's development plan and the housing requirement contained in it is more than 5 years old, and the requirement is thereby supplanted by the standard method, the requirement policy and any distribution policy contained in the development plan is thereby rendered out of date. That's, I think, the purpose of this appeal decision being produced. Is that correct?
It was to... The point that was taken by Mr Muston was that you couldn't put only policies CS13. He said you couldn't put policies CS13 into the basket of most important policies.
No, just help me with this. Look, why have you produced this decision? What's the point?
Because it was to deal with the fact that in my view, you can put CS13 into the basket of most important policies. Mr Mustard agreed that policy CS13 was out of date, but what he said was that you couldn't, but because it was already out of date and we reverted to the standard method, that you couldn't put it into the basket of most important policies.
Yeah, look, I hoped I was helping you a moment ago when I put it to you that the purpose of producing this decision is twofold. First, to show that when a requirement is supplanted by a need figure derived from the standard method, two things happen. The policy that specifies the requirement is rendered out of date, and the distribution policy upon which flows from it is also rendered out of date. Is that the reason why you produce this decision?
No, I've just answered that question and just said the reason I produced that question was in response to the point that was taken last week, which was that yes, those policies are out of date, but no, they can't go into the basket of the most important policy, or CS13, it was only CS13, couldn't go into the basket of most important policies.
Okay, right. Well, I'm sorry, I thought I was helping you, but obviously I haven't been, so we'll just have to explore this in a little more detail. When one produces appeal decisions, one bears in mind the maxim, really, that decisions by inspectors may be material considerations, but the question of whether they will be in a particular case depends upon their relevance to the matter in hand.
Correct, yes.
And their relevance to the matter in hand is determined by a range of factors. First of all, for example, whether the decision relates to the same area as the matter under consideration. So normally, for example, if it were a decision relating to North Somerset, it would be relevant. But if it's not a decision that relates to North Somerset, one immediately asks the question, well, how relevant is this? You agree that the area to which the decision relates is a relevant consideration to determine its materiality.
Yeah, what I said when we... yes, in answer to your question, yes.
Thank you.
But what I said when we put that decision in was that it was the approach that had been taken rather than, you know, so yes, I take this, that was Cambridge, obviously we are in North Somerset, but I was looking at it in terms of the approach that had been taken.
Sure, but we can just summarise things quickly. It's a different area, it's a different policy framework, and we're not dealing with the same policies written in the same way. We can agree all of those things as preliminary points.
It depends on what you mean by policy framework, because obviously the policy framework includes the MPPF. So it's not a different policy framework in that regard. If you mean insofar as development plan,
Yes.
then yes.
Good. Right. Now then, if we then look at this decision to see how relevant it might be, if we look at policy, I beg your pardon, paragraph 11 on page 2. We see that, in fact, I'm so sorry, let's just take a step back. Looking at the reasons under the heading, under paragraph 9, I beg your pardon, we see...
Sorry, did you say
paragraph 9 under the heading reasons, we see that growth 1 of the local plan expected the delivery of some 11,500 dwellings in East Cambridgeshire over the plan periods. That's the requirement.
Correct, yes.
Yeah. And then we see in paragraph 10, growth 2 formulates locational strategy. Yep.
Yep, correct.
And then growth 4 allocates houses, some 6,500.
Correct.
And what we note in paragraph 12 is that site-specific boundaries have yet to be identified by the particular plan that we are dealing with in this decision. Yeah.
Yeah.
And in this decision, we're dealing with an unallocated site.
Correct.
Yeah. So the particular circumstances in the Soham decision were a requirement in a plan that was more than 5 years old, where the issue for the inspector was, should an unallocated site be granted planning permission
Correct, yes.
in circumstances where settlement boundaries were not identified?
Correct, yes.
Yeah. And you, Mr. Banner and yourself indicated earlier that what decision the inspector in this case came to. But if we just go to paragraph 21 and read the first couple of sentences, and then I'll ask you a quick question.
Okay. Paragraph 21, did you say?
Yeah, just read, yourself, just read them, and the first two sentences, then tell me when you've read them.
Yep. Okay.
I mean, the point is, this inspector comes to a certain view which differs from that of previous inspectors, doesn't he?
Yes, that's correct. Yes.
And he says he's sure that they were right when they came to make their decision. But in any event, what we can note is he takes a different approach, this inspector takes a different approach from previous inspectors in relation to those two policies.
Yes.
Yeah, good. Good. Okay, well, having noted those things, I can make submissions on that decision. But just thinking about CS13 in particular, the requirement in this appeal is not a matter of dispute between the parties,
No,
is it?
it is not, no.
And the appellant doesn't seek to contest the figure that's generated by either the core strategy or indeed the standard method.
Yeah, but yeah, I mean, this appeal goes forward for the purpose of 5-year supply assessment on the basis
Yeah.
of the standard method figure.
Yeah. So I'm just puzzled, given that the requirement is not a matter of contention between us, and given that, unlike in the Soham case, we're dealing with an allocated site, why are settlement boundaries or requirements key issues in this appeal?
Well, settlement boundaries, because technically my site sits outside the settlement boundary. The SAP, the Site Allocations Part 2 plan, doesn't amend settlement boundaries to take account of allocations, and this is a housing scheme where the starting point for the assessment is the development plan, and the development plan has the housing requirement and then the location, distribution and reference to the settlement boundaries set out in CS 14. So it is relevant when the starting point for assessment of a planning application is the development plan. Yes, the figure has been replaced by the standard method, but it doesn't, sorry, I just realised I was turning away from the microphone, but it doesn't mean that we ignore the development plan.
Well, do you ignore the requirement that's set out in CS13 or don't you?
No, because what I'm saying, the point that I made right at the start of this is that the core strategy and therefore the site allocations plan, the policies that are set out in those plans are predicated on the delivery of that that 28,895 figure. So the policies CS13 or CS14, etc., SAP2 allocations, they're all set up to deliver that figure.
Well, that's true. I'm just wondering why it's relevant in this particular case, or why it's particularly important in this case, on your evidence. It's a short point. It's going to be a matter of submission, I think, but I'd like just to put to you this simple point, that CS13 has not been abrogated. It remains part of the development plan. But for the purposes of this appeal, the question is the level of need that's indicated by the standard method delivered, in part at least, by the 5-year supply? That's the issue between us, isn't it? So we have a standard method need figure, we derive a 5-year requirement from it, and we ask ourselves the question, is the supply adequate to meet that need figure? That's the issue between us. Yeah?
Yeah, in terms of the determination of whether or not there's a 5-year housing land supply, yeah.
So we don't need to worry about what CS13 says. It's irrelevant, isn't it?
No, it's not irrelevant. You know, it's part, you just said yourself, it's part of the development plan. We
Well,
don't
it is,
simply disregard it. It's not irrelevant because so much of the plan is framed around that housing figure. As I said right at the start, that the primary, the first objective of the plan is delivering the housing figure that's set out in CS13. So therefore, no, it's not irrelevant.
Well, last couple of questions on this topic. It is irrelevant for this reason. You need the requirement, amongst other things, to derive the number of houses that must be delivered in 5 years for the purposes of asking, is there a 5-year supply of housing? You don't need to use CS13 for that. In fact, you can't use CS13 for that purpose. You have to use the standard method. Therefore, for the purposes of this appeal, CS13 cannot be sensibly the most important policy, can it?
I don't agree with that.
All right, that's fair enough. I will have to differ on that point, and I can make submissions on it. Okay. Now, we looked at CS14 earlier, so I don't need to cover that ground again. What we'd better do, just to wrap up, is turn next to CS4, if you would please. So you need to turn to D1. And you'll find CS4 on page 36. Now, CS4 cited as one of those policies which the Council relies upon in the reason for refusal. And we go to your page 68, and you see there that whilst you say it's a most important policy, we'd agree with you on that, it's not up to date because of certain aspects relating to veteran trees. Yep.
That's correct.
Just in a nutshell, why do you say that the whole of CS4 should be regarded as out of date, or part of it if you like?
Because when we're dealing with the approach to veteran trees, the approach in here is actually different, or just differs to the approach in 180 of the MPPF, 180C of the MPPF.
So let's have a look. Go to paragraph 180
Yep, I'll have it open.
of the framework. Now, what's the problem? Help me understand.
Sorry. It's actually, I would actually say, if anything, 180C of the MPPF is slightly more onerous than policy CS4.
Tell me why. Take me to the relevant part of the framework. And
Okay,
then I'll ask you some
I just said
questions.
180C.
Yes.
180C is obviously talking about loss or deterioration of irreplaceable habitats such as veteran trees, unless there exist wholly exceptional reasons and a suitable compensation strategy exists. It's the emphasis in paragraph 3 of CS4 is just different.
Well,
It's different emphasis.
what the framework says, as you say, is there should be wholly exceptional reasons and a suitable compensation strategy for the loss of veteran trees.
Correct,
Yeah.
yes.
What CS4 says is we should protect, amongst other things, veteran trees.
Correct,
Yeah.
yes.
Now, if we are protecting veteran trees, well, that's what we're doing. We're preventing their loss. There is no inconsistency between the framework and CS4, is there?
Okay, I think there is a difference in the emphasis between the two for the reasons that I've set out. But as I said, our starting point is that we comply with both 180C and CS4 in any case.
Okay. But you'd accept, wouldn't you, that both the framework and CS4 seek to prevent the loss of veteran trees? Yeah?
Yeah.
Yeah?
Yes, I said yes.
Yes, good. Now, so then let's see what you've got to say about CS4. And the framework. Now, if we turn to your proof on page 59, I think what you do there is just summarise what Mr. Clarkson's got to say about the scheme's compliance or not with that particular policy. Is that right?
That's correct, yes.
Yeah. And what I don't see there, though you agree with what Mr. Clarkson says, is any particular concern by Mr. Clarkson expressed as to the loss of veteran trees.
Well, obviously, our starting point is that there is no loss of veteran trees.
Pardon?
So I said our starting point is that there is no loss of veteran trees. So I wouldn't expect him to be expressing a concern about something which in our view isn't happening.
Well, when you talk about the loss of veteran trees, do you mean knocking them over and moving them, or do you mean keeping them alive?
I don't think anywhere that we say we're going to knock them over.
Well,
that's...
as I understood your approach to G7, and I'm going to ask you one or two questions on this because we can talk to Mr. Clarkson about this in due course, but you did have quite a bit to say about ecology when you gave evidence in chief. As I understood the proposals in relation to Group G7, there is or was a standing tree.
G7, there is a standing tree.
Yeah, there is a standing tree, and there's a fallen tree which is still alive.
Yes.
Isn't there? Yes.
Yep.
And the proposal is to transplant the standing tree
Correct.
with a view to it still being alive when it's put back in the ground.
Correct,
There's
yes.
a risk attached to that, which I'll ask Mr. Clarkson about. But as I understood the proposal, the tree that's fallen but still alive is going to be moved as well.
Yep.
And when it's moved, it will not be alive anymore, it will be dead. Because you're not proposing to transplant it, you're proposing to pick it up, put it down, and it will be dead.
It'll be in the same state that it currently is.
No, it won't, because at present it's alive. I mean, perhaps you don't know.
I think
But
it is.
as I read Mr. Clarkson's evidence, and I'm not going to take you to it, I can ask Mr. Clarkson about it. As I read Mr. Clarkson's evidence, the fallen tree is fallen but alive, and it's not going to be transplanted because you can't transplant a fallen tree. So when it's put somewhere else, and we're not sure where it's going to go, but we can probably guess roughly, when it's put somewhere else, it will be dead.
Yeah, that's a point to take up with Mr. Clarkson. I
But
think.
you don't know the answer to that question.
No, that's not my understanding.
No, but were it to be a correct proposition that one of the trees, when it's picked up, will not be transplanted, it will just be plonked down on the ground and it will be dead, that would result in the loss of a veteran tree, wouldn't it?
But they're veteran, but they're not. They're veteran because of their ecological status, which is the dead heartwood, and therefore, whether the tree is alive or dead, in ecological terms, is not. My understanding is that doesn't then change the status of the veteran tree in ecological terms.
Well, do you know what? This is probably a topic for Mr. Clarkson, because as I read Mr. Clarkson's evidence, it actually does matter whether a tree is alive or dead, at least from the point of view of the orchard tooth crust fungus, but we're going too far down the
okay,
ecological
yes, yeah,
route. We'll ask Mr. Clarkson about that. Okay, good. Right, thank you. 10 minutes left. DM9 next, which is D2. Now, why is D2 out? Why is DM9 out of date?
It's the same reason as we have just dealt with in relation to CS4.
Well, which bits?
It's the part that, again, the part that deals with the veteran trees. As I've said, it's bullet point 1, 2, 3, 4, 5, bullet point 7. I've just said it has a different emphasis. It's the same reason as for CS4.
Okay. Well, I can make submissions on that. There's no need to cross-examine any further on that. Good. Thank you. So would you just give me a moment? There's
Yep.
probably no more to ask. No more to ask on policy, except for perhaps one thing. You say in your evidence that, well, you say all sorts of things about the council's failure, as I suppose it must be put, to cite in the reason for refusal DM8. Yep.
Yep.
And you say I can infer from that all sorts of things, and you do. Yeah?
Yes, correct.
In fact, on page 22, we'd better go there. Paragraph 4.31, you've got 7 things to say there
Yep.
about the failure to identify DM8 as a reason for refusal. Yeah?
Yep.
All I put to you is there is nothing that DM8 has got to say which is not said sufficiently by CS4 to allow Mr. Phillips and Mr. Clarkson to have a jolly good argument about veteran trees, bats and other ecological issues. Agree?
Yeah, I mean, the point there, sorry, the point there was that, that DM8 is, for want of a better term, the partner policy to CS4, and given that the onus was on the council to make sure that the reasons for refusal do contain all relevant policies, and are there full reasons for refusal, and given that DM9 was cited when that's the partner policy to landscape policy, it was just, I wondered whether it was a deliberate exclusion of DM8, but you're right, in terms of the answer to your question, yes, it will enable, the ecologist will, I'm sure, cover DM, I've lost just track of what it is now, DM8 in their discussion.
Right. So, if I read your paragraph 432, I don't need to, I can make a note, can I, that notwithstanding the failure of the reasons for refusal to specify DM8, you'd accept that the council and the appellant join issue in respect of the impact of the scheme on matters of biodiversity and ecology.
Well, I think with regard to the... Sorry. With regard to the biodiversity point and the net gain, if that's where we're going with that one, I think it's
I'm not seeking to introduce biodiversity as
okay,
reason for refusal.
fine, that's okay. I just wanted to check that. Okay.
Okay, good. All right. Okay, last questions. What happens in the do-nothing scenario? Yeah?
Yes.
Just out of interest, you appreciate, don't you, that the veteran trees are covered by a TPO?
Yes, I'm aware they're covered by TPO.
So were this appeal to be dismissed, obviously what cannot happen is any action by the landowner to damage or destroy those trees by lopping, chopping, felling or doing any of the things you're not allowed to do.
That's not happened to date, and I'm not, well, that I'm aware of anyway, and you have to have a pretty... No. I hope you're not saying that landowner is going to be that irresponsible.
I'm not saying that at all. I'm just in the do-nothing
scenario. In the do-nothing scenario, yes, of course. There would need to be consent to do works.
Yeah. So the veteran trees are protected. That's the first point.
They're protected by tree preservation.
Yeah.
Yes.
And the second point is one could, if one knows that there is a rare fungus growing on some of the, or at least on one of the live trees, one could take steps to ensure that that tree or trees, it turns out to be more than one, is not damaged by, for example, grazing horses.
That's correct. It is tree singular at the moment as a result of the last time that has been surveyed. It's just in one tree. Mm-hmm. And when you go out to the site, you will see that in response to the advice of Mr. Clarkson, the landowners have already fenced off that tree to avoid the horses getting to the dead hardwood. Yeah, good.
Third point, I suppose, if one were to take access via, let's say, Grange Farm Road, I'm not going to question the rugby club, let's just say Grange Farm Road.
Okay, yep.
There'd be an opportunity, wouldn't there, for whoever were to develop the site in that way to take steps to deliver biodiversity net gain on the southern field.
They could deliver BNG on some further, whether that would, obviously, in order to deliver BNG, currently, you only have to deliver, you only have to get to, say, 1%, for example. So what that would look like on that field is is another matter. It may be that, you know, obviously I'm not an ecology expert, so I don't know in the event that the orchard were excluded from the planning application, how that net gain would be achieved.
Fine. So, no, actually, I'm going to stop there. I can make submissions on those answers. There's no need to go any further. So thank you for your patience. I've had my allotted time. I'll stop there.
Well, thank you, Mr. Leader. I just want to make it clear that I'm not constraining you now, providing your content that you've asked all the questions you want. But
they are all the questions I wish to ask. Thank you very much.
Thank you. Okay, well, we're nearly 1 o'clock. I've got a few questions, but it's mainly on clarification points, so I'm not going to take very long. Have you got... No.
Can I just raise, on the tree preservation, it may be helpful if we can have a chat outside about what the status of a TPO is in relation to a tree that's already fallen over.
Okay.
Because we might want to try and reach agreement to assist the inspector. I'd just invite Mr. Leader to work with me to see if we can find it. The answer isn't straightforward, actually, but it may help you because it may be of some relevance.
Something I'm sure you can discuss, as you say, outside.
Ministry.
Okay. So all I'm really saying this for is obviously we're approaching 1 o'clock for lunch. If you're not going to be too long in re-examination, then we'll carry on. Okay. So my questions...
So we just want to check, is the live feed working? Because it did just go down.
Yes, something just went off and then...
I just wanted to check before.
Are we still...
Okay,
all
sorry,
right, okay, so we are still going. Okay, so just bear with me. So I'm not going to explore things that I think I've heard answers to, but there were some points in here I think that I just wanted some clarification on. Well, I'm sure nothing turns on this, but on your page 17, you've in 413, you're telling me appendix. Is there a number to follow? Sorry, you see the last line of your 413.
Yes, no, you are quite right. Yeah. It is, if you just bear with me. It is appendix 2.
Appendix 2, okay, thank you. So I can look at that. What's this one? Yeah, I've not correlated all of the points in here against that list of draft conditions, but when I got to your page 39, and it's the last bullet point that goes over the page, and you're saying that an arboricultural method statement could be used. Does that form the subject of one of the suggested conditions as it currently stands? And if it doesn't, presumably that's one thing that you'd be looking at.
Yeah, exactly that. I can't recall off the top of my head, sir. But yeah, it can indeed be included as a condition.
So the intention is, if it isn't already one of the draft conditions, then one would be formulated to incorporate that. Okay, thank you.
I think it might be in there, but I can't recall.
Can't be certain, no.
I wouldn't want to give you the wrong answer, and we're going to do conditions later today anyway, so.
Now I'll have to read this one again, but your page 41, the top bullet point on there, now, is there a not missing?
There is, I've corrected that on mine as
There's
well,
a not missing,
yes.
okay,
Yeah, it should say, if an alternative access cannot be found.
Yes. Okay. The only other, well, the next point that I'd got flagged was at your para 563, And again, it was just to highlight a point that I think I highlighted with Mr. Muston, that there is, the parties agree that there would be harm caused to the setting of the Grange, but that's classed as less than substantial.
That's
and the parties
correct.
agree.
The parties are agreed on that. It's confirmed in the Statement of Common Ground,
Yep.
And it's that the harm is the traffic that would be using the road rather than the development itself.
Okay. Okay, thank you. That might be it. Oh no, what's this one? No, I think that was all that I wanted to ask you to clarify or question you on. So thank you.
Thank
So,
you, sir.
Mr. Banner, any
Ms. Benton,
re-examination?
just 2 points in re-examination. I'll deal with the most recent one first, which related to veteran trees. Could you just take up paragraph 180D of the framework? Sorry, 180C of the framework.
Yes. Yep. I have it.
And so firstly, development resulting in the loss or deterioration of irreplaceable habitats, such as veteran trees. If the value in terms of habitats of a veteran tree doesn't turn on whether it's alive or dead, and if the tree were to die but to be kept on site and its habitat, the habitat it provides, being preserved, what would the analysis under 180C be?
My conclusion would be that there is no loss or deterioration of the veteran trees. As I said, my understanding is that it's in relation to the ecological habitats that they provide, and that would be maintained.
And if for some reason that's not right, and that simply the very fact of them dying means that for the purpose of 180C, the wholly exceptional reasons apply.
Yes.
What's your judgment upon whether the fact that the value is actually not in the dead wood rather than whether they're alive or dead, the betterment that you've referred to, and the fact that the uncontested arboricultural evidence is that they're going to fall over and die anyway.
Yep.
What relevance is that to considering whether there are wholly exceptional reasons in the circumstances?
It is extremely relevant to it, and I do deal with, in my evidence, the wholly exceptional reasons and address them in full and conclude that those matters, alongside other reasons such as delivery on housing on an allocated housing site, etc., together as a package amount to wholly exceptional reasons.
Thank you. Then the next and second point, the last point, fairly early on in the cross-examination, you were asked about the most important policies and what was and wasn't within the basket of most important policies and whether they were out of date. And you had a discussion about policy CS 14.
Correct, yeah.
And whether or not that was a most important policy on the facts of this case.
Yes.
And it was put to you, well, this wasn't a case where we were developing outside the settlement boundary on an unallocated site, so there's no conflict with policy CS14, and that was a material distinction from the two appeal decisions in CDF 6 and F13,
Correct.
where there was a conflict.
Yep.
Just help us on this. To qualify as a most important policy, or for a policy to qualify, I suppose, does there have to be an allegation of a breach of that policy? Are we only looking at most controversial policies?
No, it doesn't have. There doesn't have to be a breach of policy to qualify as the most important policy.
And could you take up SOAM in this context? We know, if you remember, that the only policy in relation to which it was alleged that was non-compliance, the only controversial policy was Growth 2.
Correct, yes.
Growth 1 and Growth 4 were in the basket of most important policies as well, despite them not being controversial
Yes.
or allegation of compliance. what does that suggest to you about whether there is a material, for the purpose of judging whether they're most important policies, material distinction from those appeal decisions you referred to in relation to whether CS14 is the most important policy or not?
Yeah.
The fact that in those cases there was an allegation of breach, in this case there isn't an allegation of breach, does it matter?
No, I was going to say it doesn't matter, and I think that's where the Soham decision is helpful in that respect. This, as I said in my evidence, this is CS14 is a housing policy which deals with the housing distribution. Whether the policy breaches it or not doesn't affect whether or not I consider it to be a most important policy.
Thank you. Those are all the questions. Thank you, sir.
Okay, thank you. Thank you, Mrs. Ventham. You may, well, I would say resume your seat, but obviously we're going to adjourn for lunch in a moment. So let's be clear. That's, when we come back after lunch, we've got the conditions session and the section 106 to deal with. I've not got updated versions of either of those. Have they been prepared? I'm seeing some nods.
You get them printed over lunch break.
Yes.
And emailed as well. We
Yes,
can
and
get them
emailed to you as
Yes,
well.
if you can do that.
We've got Mr. Quartermain is going to deal with conditions, Ms. Ventham's colleague, and Mr. Charlton, who I think is just over there from Clark Wilmot, who led on the 106 drafting. He's going to deal with the 106.
Okay. Hello. Okay, right. Are those documents available now at all? If so, I can look at them over lunch, or do they need printing off?
Well, that's good. Right hand in the language.
Yes, please. Thank you. Yep, that's helpful. Thank you. Okay, thank you. Thank you. Anything else before we adjourn? What about the latest list of conditions? Is that available?
We can print those out for you over the break.
Okay, yes, I'll... let's do it like that, and yes. I'll take, I'll go till 2 o'clock. Is that okay? We don't need to take the full hour, but I think that's going to be a reasonable break for people to read things, etc. Okay, so I'll adjourn then now, and we'll resume at 2 o'clock. Sorry, just as I've said that, is there a preference for which we deal with first, conditions or section 106? I'm fairly flexible on that, so I don't know if the parties are geared up to do one way or the other.
Sir, I don't think we have any preference one way or the other.
There's no preference. Let's do conditions first. Okay. So, as I said a moment ago, adjourn now. We'll resume at 2 o'clock. Thank you.